do that?
James will tell you how to do the amendment. There's talking points about it. It just basically talks about what the White House and Zwoниtzer's attorney told us the other day.
Do I need to read this?
You have to explain the amendment.
Committee will come to order without objection. The chair is authorized to declare a recess pursuant to Committee Rule 2, House Rule 11, Clause 2. The chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. We now recognize the gentleman from Wisconsin to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Pursuant to notice, I call up the report recommending that the House of Representatives cite Mark Zwonitzer for contempt of Congress for purposes of markup and move that the committee report it favorably to the House. The clerk will report.
Resolution recommending that the House of Representatives sign.
Without objection, the report be considered as read and open for amendment at any point. Before recognizing myself for an opening statement, I forgot to recognize our newest member. The gentleman from Ohio, Mr. Ruley, was recently elected and, of course, as you all know, sworn in, gave amazing, I thought, remarks on the House floor. Mr. Ruley was elected to represent Ohio's 6th congressional district. Before this election, he served in the Ohio Senate. We're excited to have him join our committee. The Ruley family has had grocery stores in Youngstown for like 1,000 years, and it's great to have you now as part of the Judiciary Committee, so we welcome you to the committee. Yeah, we should clap for that. Chair now recognizes himself for an opening statement. President Biden willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. That is what Special Counsel Herr found on page 1 of his report. On at least 3 occasions, Joe Biden, quote, read aloud classified notebook passages to his ghostwriter nearly verbatim. On page 200 of his report, Special Counsel Herr concluded that President Biden's disclosure of classified materials to Mr. Zwonitzer risked serious damage to America's national security. It's worth repeating that Special Counsel Herr said that President Biden had strong motivations to share classified information with his ghostwriter. In fact, he had 8 million reasons to ignore the rules. Joe Biden shared some of the classified materials he wasn't allowed to keep, with his ghostwriter, who was writing a book for which he was receiving an $8 million advance. All this, and yet Special Counsel Herr declined to prosecute Joe Biden because, quote, he is a sympathetic, well-meaning elderly man with a poor memory. And that brings us to today. Following the release of Special Counsel Herr's report, we subpoenaed 6 categories of information from Mr. Zwonitzer related to his work on President Biden's memoirs, including transcripts and audio recordings of his interviews with President Biden. To date, Mr. Zwonitzer has refused to comply with the committee's subpoena. The responsive documents in Mr. Zwonitzer's possession are necessary for our oversight. As an initial matter, we must know the extent to which President Biden disclosed classified materials to Mr. Zwonitzer and his intent behind disclosing that information. In order to do so, and to determine whether Special Counsel Herr appropriately carried out justice by not prosecuting the president, we need the audio recordings and the transcripts. Put simply, they are the best evidence of the president's mental state. Remember, on page 207 of his report, the special counsel said, Mr. Biden's memory also appeared to have significant limitations, both at the time he spoke to Zwonitzer in 2017, as evidenced by their recorded conversations, and today as evidenced by his recorded interview with our office. Special counsel concluded that some jurors may have reasonable doubts because President Biden's apparent lapses and failures in sharing the classified information with Mr. Zwonitzer would appear consistent with the diminished faculties and faulty memory he showed in the recorded interviews with his ghostwriter. Not only did Special Counsel Herr decline to prosecute President Biden, he also declined to prosecute Mr. Zwonitzer for obstruction of justice. Special Counsel Herr found that, quote, after learning of his investigation, Mr. Zwonitzer deleted digital audio recordings of his conversations with Mr. Biden, where President Biden, in fact, disclosed classified information to him. Audio recordings that the Special Counsel Herr found had significant evidentiary value to his investigation. We need to understand the extent to which Mr. Zwonitzer impeded Special Counsel Herr's investigation by deleting these recordings. But to do all of this, the committee needs the information we subpoenaed from Mr. Zwonitzer. No legal or constitutional privilege protects the information subpoenaed from disclosure. Mr. Zwonitzer has a legal obligation to turn over the requested materials pursuant to the subpoena, and his willful refusal to comply with our subpoena constitutes contempt of Congress. Our oversight is too important to allow Mr. Zwonitzer to willfully disregard our lawful subpoena. Now I yield to the ranking member for an opening statement.
Mr. Chairman, we have an important oversight role in this committee. We oversee the Department of Justice, federal courts, federal antitrust policy, civil rights issues, federal law enforcement, and so much more. But we're not here today because of any of these legitimate areas for oversight. We're here today because after spending $20 million chasing dozens of conspiracy theories, MAGA Republicans have come up with nothing. In fact, the Republicans' stunning failure was made painfully obvious just yesterday when the Supreme Court ruled that the conspiracy theory underlying their signature investigation into social media companies was, quote, clearly erroneous. We're here today because there's a presidential debate tonight, and MAGA Republicans have decided the best way they can help President Trump is by bullying and intimidating a private citizen to obtain information about his highly sensitive and deeply personal conversations with President Biden. We're here today because Republicans are, in a word, desperate. This contempt resolution against Mr. Zwonitzer is an abuse of the committee's oversight authority, pure and simple. Decorum and collegiality have clearly departed this chamber in favor of MAGA extremism when this committee harasses a private citizen to intimidate him into giving the chairman whatever he wants in his quest to find something damaging to use against President Biden. Earlier this week, we received a letter that White House counsel Ed Siskel sent to Mr. Zwonitzer's attorney in which the White House said, quote, the committee's subpoena seeks broad swaths of personal information that President Biden provided to your client in confidence as part of the process for writing his memoirs. The vast majority of this information is private. The committee's subpoena is therefore a congressional subpoena for the president's information, which unavoidably pits the political branches against one another. Unfortunately, the committee has thrust your client into the middle of this interbranch conflict. The letter continues, quote, your client is not authorized to provide any of the president's information until it has been reviewed for executive branch confidentiality concerns and a resolution of these constitutional issues between the two branches has been reached, close quote. Mr. Siskel also wrote to the chairman directly, advising him that, quote, the executive branch is ready and willing to engage in good faith with the committee in response to its purported interest in this matter. In other words, the committee's fight is not with Mr. Zwonitzer. It's with the executive branch, and that's who it should be negotiating with. And according to Mr. Siskel's letter to the chairman, Republicans have not engaged in negotiations with the White House at all. But we're not here today to engage in good faith negotiations. We're here today because the majority has instead chosen to bully and intimidate a private citizen because they think they can break him before they break the executive branch. They desperately want the audio recordings of Mr. Zwonitzer's dozens of hours of private interviews with President Biden conducted when they worked together on Promise Me, Dad, a memoir detailing President Biden's loss of his son when he was vice president. I would like to read some of the entries from this book so that as we move forward with this ridiculous contempt proceeding today, we can all keep in mind what kind of information and recorded conversations Republicans want to acquire and weaponize against President Biden. In his book, the president recalls telling his dying son, quote, I will never stop doing everything I can to keep you alive, to keep you with us. It's okay if you go now. It's okay if you don't fight anymore. It's okay to go to sleep. He recalls his son telling him, you've got to promise me, Dad, that no matter what happens, you're going to be all right. Give me your word, Dad. You're going to be all right. President Biden recalls making an entry in his diary after his son's diagnosis, writing, quote, no Thanksgiving would ever be quite the same. I pulled out my diary and started to write. I did have one big item for my own Christmas list that year, but I was keeping it to myself. Naval Observatory, November 30th, 2014, 7:30 p.m. Just home from Nantucket. I pray we have another year together in 2015. Bo, 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 Bo. He recalled making another entry. As Air Force 2 took off, I felt compelled to open up my diary and write, March 29th, leaving MD Anderson with hope. Bo is an amazing man, as is Hunter. He is staying with Bo until the next procedure. I'll be coming back. I paused. What else was there to say? I was afraid if I really opened up, I would give in to a lurking despair, and I could not allow that to happen. I could not allow Bo or anyone else to see that, ever. I set aside the diary until the flight was nearly over, then picked it up again to add one line. Just landed, 6:07. I feel so goddamn lonely. He also recalls watching his son wither before his eyes. My eye was drawn to Bo as we talked. It wasn't yet late in the evening, but it was already tiring. He was so gaunt, and his face seemed drained of color. I could see the outlines of the leg brace through his pants. Bo had been losing recall of more and more proper nouns lately, and he seemed less willing to fight through it. Ashley, Bo's sister, had told me that Bo was no longer inviting her into the room for his speech therapy because his decline really bothered him. Bo said almost nothing that chilly February night in Washington. He would whisper something to his brother instead, and Hunter would speak for him. Unquote. I think most parents would agree, watching your child suffer and die is the worst possible torment you can imagine. And that tragedy, that heart-wrenching, gut-churning agony that President Biden endured is what Republicans want to use against him. Their desperation knows no bounds. And don't let them pretend here that they have compassion for President Biden's loss or that this request has anything to do with oversight. If this committee really wanted to conduct oversight, they would work in good faith with the DOJ and the White House, not employ intimidation tactics and punitive subpoenas against a private citizen. They don't want to conduct legitimate oversight. They want to get those audio files to help MAGA Republicans this election cycle. Mark my words, if Republicans get these files, their priority will be getting altered and context-free audio clips into Republican campaign ads, not doing the real work of the American people. This is about digging for embarrassing audio of President Biden when he was in a vulnerable state discussing the death of his son. This is about their political game. Oversight Chairman James Comer said so himself in an email. He said if he gets the tapes, he will release them for the purpose of demonstrating, quote, Biden's mental state to convince, quote, swing voters. What more evidence do you need? And in case I have to explain this, demanding material to bolster your political campaigns does not constitute the kind of legitimate legislative purpose that makes a subpoena enforceable in court. Despite Republicans' desperate attempts to feign a substantive need for these files, one simply does not exist. Today's markup is about making the chosen Republican leader, Donald Trump, happy by hunting down any possible vulnerabilities of President Biden. And to achieve that goal, this committee is willing to put a target on the back of an American citizen, a private American citizen who has already been cleared of wrongdoing in this very matter. Frankly, this is frightening. Trump is weaponizing this MAGA Republican-led committee to get information on his opponent, President Biden, at any cost, even if it means publicly flogging an American citizen trying to live a private life. And I have to wonder, is this just the beginning? Is this what we have to look forward to? If Trump gets a second term, is this the playbook? Anyone, public official or private citizen, who doesn't give Trump what he wants will have the weight of the government hammered down on them? Anyone who questions Trump's authority will have his name fed to Trump's ravenous far-right supporters to instill fear and submission. Anyone who asserts their constitutional rights to get in the way of a Republican agenda will be held in contempt by Trump's enablers in Congress. That is not an America I want to live in. That is not the American democracy I have devoted my career to fighting for. And I know this is not the country the American people want. Every American should sit up in fear watching this public attack on a private citizen. If he isn't safe from this kind of government abuse, what makes you think you are? I urge members to oppose this dangerous resolution, and I yield back.
Gentleman yields back. I would just add, Mr. Zwonitzer is in fact a private citizen who tried to destroy evidence once an investigation was announced, the very evidence we seek in our subpoena that he fails to comply with. That's why we're here. Without objection, all other opening statements will be included in the record. The chair now recognizes himself for the purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to the
Without
committee.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes himself to explain the amendment. The amendment makes a grammatical change on page 5 of the report. It does not change the sub of the report. Who seeks recognition? Gentlelady from North Carolina is recognized.
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized, excuse me.
Thank you. I am not surprised that the majority has taken this ridiculous fight with the executive branch to a private citizen. They're bullies. Mr. Zwonitzer is a writer and director, not a political figure. And his attorney has repeatedly explained that Mr. Zwonitzer is not in a position to determine what materials he can share with this committee, especially when the executive branch has asserted significant interest in this material. Going after a private citizen who is now caught between two branches of government is not only legally bankrupt, but also an unjustified abuse of power. Mr. Zwonitzer set out to write a memoir in President Biden's name about the death of his son, Beau. Nothing more. He's now caught in a legal battle in which he has no stake, all because the majority on this committee is desperate to get its hands on any material related to President Biden in order to justify its relentless and fruitless investigation into anything and everything related to this administration. Congress is supposed to work for the people, for people like Mr. Zwonitzer, who in addition to his work with President Biden on his memoir, is working on a documentary about the creation of the Transcontinental Railroad. Instead, the majority is attacking the people, the very people it is supposed to protect and represent. I refuse to be associated with this attack on a private citizen, and I refuse to be associated with the members of this committee who are leading this charge. And as the ranking member said, this has been timed for the debate. It has been timed for the election. It is nothing more than a political stunt, and it is an abuse of power. Thank you, and I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from North Carolina is recognized.
Thank you, Mr. Chairman. I wonder if my friend from North Carolina would engage in a colloquy. So if I'd like to pose a question to Ms. Ross, given what was just said. Mr. Zwonitzer was the ghostwriter of what you just described, and the ranking member before you described as a book about the death of President Biden's son. Why was President Biden, according to Special Counsel Hur, reading from classified materials about Afghanistan to his ghostwriter in a book that was solely about the death of President Biden's son? You don't care to answer? I can understand.
I didn't yield, and I don't have any information about that.
I see.
So I suggest that you use your 4
I'm not looking
minutes
for I'll reclaim my
to address
time then.
the contempt
Time
resolution.
belongs
my
to the
time.
gentleman from North Carolina.
Yeah, it's my time. I offered to engage in a colloquy which would have the effect of refuting the absurd allegation that you made. But I can understand why you don't want to answer, because it's an irrefutable point. No one that I know about who's interested in securing Mr. Zwonitzer's compliance with the lawful process served upon him has had anything to say about the death of Beau Biden. No one's read from the parts of the book about Beau Biden to frame this matter. The question is, why was Joe Biden reading from classified materials to somebody without a security clearance in a matter for which he was going to be paid $8 million? And this Congress needs to investigate and consider what is necessary, and it is the committee vested by this House of Representatives with inquiring into the grounds for impeachment of the selfsame president. And the hypocrisy is mind-blowing. I wonder if Steve Bannon could imagine that someone might, for a political purpose, pursue a contempt resolution. But there's no political purpose here. It is the responsibility of this person who received classified information to provide what he has to this committee to evaluate. It's just almost, it's unspeakable. I was thinking about the legislative purpose that was cited in order to secure the personal private income tax returns of President Trump. We can all say with certainty that there was no motivation of a political sort involved in that. Wow. Calling the tune requires playing by the tune. But Mr. Zwonitzer is an ordinary citizen. The process served upon him to compel him to provide information to this committee. Straightforward. He has, with the most frivolous of arguments, flouted his responsibility under law. It is this committee's responsibility to proceed. That's how it works. It's very simple, nothing more to it than that. It's time we get on with it. I'm fully in support of the A&S. Mr. Chairman, with that, I yield to anyone else who wants the time.
The time.
Mr. Biggs from Arizona.
Thank you very much. When we listen to the first two speakers for Cross the Aisle, it is clear that they are infected with TDS. The ranking member could not utter a sentence without mentioning MAGA. But it gets to the point that Mr. Bishop, my friend, made. The ranking member said that we want to get a hold of, and quote, sensitive and deeply personal conversations with Zwonitzer, close quote. This was for a book that was going to be published. These were classified documents. And you want to tell us, oh, we want access to sensitive, deeply personal conversations with his ghostwriter who was making a bundle of money to publish a book. That's not deeply sensitive and personal. What it was illegal. The special counsel said he had classified documents from the time he was even the senator, some of which were still classified. And then Zwonitzer, showing a guilty mind, destroyed evidence when he was confronted about it. Yield back.
Gentleman yields back. Who seeks recognition? The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. Today is a sad day in the history of this particular committee, that we have stooped to the point of trying to intimidate and bully a private citizen, a journalist, no doubt, who has collaborated with President Biden at some of his most sensitive moments about very sensitive issues, the death of his son. And this committee is using its power to try to get at some audio tapes between this journalist and President Biden, wherein President Biden is discussing these kinds of sensitive matters. And the only reason why the other side is doing it is because they're now trying to scrape up as much information as they can to make Donald Trump happy, because he needs fodder for campaign ads. And so that's why this audio is important to my friends on the other side of the aisle, just to appease President Trump. And, you know, fact of the matter is this is the outgrowth of $20 million in taxpayer money having been spent by this committee and this Congress investigating President Biden and Hunter Biden, trying to find evidence of a criminal gang as they have billed it. They have come up with no evidence after spending that much money and all of the staff time. They've not been able to come up with any evidence of corruption by President Biden or his family, which they call a crime family. This committee has been front and center in that investigation. It has been fruitless. In addition to this committee, you've had folks like Robert Hur, a special counsel, a holdover from the Trump administration, special counsel, who looked into classified documents that were found and turned over by President Biden that were in his possession after he had left office. And Robert Hur looked into it to determine whether or not there was any criminal liability. And he found none, but he chose on his way out, issuing a final report, to include in that report inappropriate characterizations of the president's mental competency, President Biden's mental competency, for the express purpose, that was a giant breadcrumb offered to this committee to enable them to follow up on that as they are doing right now. So in addition to those fruitless rabbit hole investigations, now we have morphed into, okay, we need to get the audio files of the ghostwriter for President Biden. Isn't that a ridiculous use of this committee's time, that we're sitting here and a private citizen is being bullied and intimidated and threatened, a journalist, by this committee? It's really a sad day. The American people see that this is doing nothing to make life better for them. This is just an outgrowth of a rabbit hole investigation. It'll go nowhere. We're wasting our time. The American people expect us to do the business that makes their lives better. That's what we need to be about, putting people over politics. And so I will yield back the balance of my time. This is a sad day.
Gentleman yields back. Who seeks recognition? The gentleman from California is recognized.
If the MAGA impeachment investigation was a missing person, we'd all have Amber Alerts on our phones a long time ago. And that's what this is really about. They promised you that they were going to have the goods to impeach the president, and they failed. They came up short. You've got nothing, nada, zilch, zero. It's a big goose egg. And so you're just screwing around now on the margins with this batting practice, exhibition, preseason game-like exercise because you're not ready for prime time. I'll yield to anyone who'll tell me when you're bringing your impeachment vote. If anyone wants to tell me, because you promised the American people you were going to impeach President Biden. So bring it. I'll yield. Bring it. Come on. You promised the American people. Bring it. Don't screw around with this
I'll be glad
stuff.
to speak to that.
Yeah. Do you have a vote, Mr. Bishop?
Yeah.
Okay, make the motion.
Here's
make
the
the
answer.
motion.
Here's the answer.
Make the motion.
No,
Come on.
you didn't ask me to
Come
make a
on,
motion.
big
You
man.
asked me to
You talked
explain
about
when
this
it would
all the
occur.
time.
You want me to
Come
answer
on.
you? Was it a question
You're
you want to
a big
answer?
man, right? You talk about impeaching the president. Bring the motion.
I'll be glad to answer your
Come
question
on.
if you want an
Bring
answer.
the motion.
You
Come
mean
on,
you don't
Biggs.
want an answer?
Come on, Biggs, bring the motion. Stop wasting our time. You're wasting our time.
Here's the answer.
You're
As soon
wasting
as
our
they
time.
stop
Bishop, come
stonewalling
on.
the investigation,
Bishop,
we can
you
get
got
to the next
nothing.
step.
You guys got nothing because Joe Biden has been acquitted. And this is just a pathetic post-game of a exercise that yielded nothing. This is embarrassing. It's embarrassing and it's a waste of time. You have people sitting in here who are wearing shirts that say moms demand action. Do you think moms are demanding impeachment? No. They want their kids to be safe in their classroom from gun violence. You actually sit on a committee that can do that. Man, come here and do something. You have a colleague right now who's trying to put the Attorney General in handcuffs with this Anna Paulina lunacy because she can't accept that the former president was arrested and convicted. In her own district, she has some of the highest home ownership insurance rates in the country. Her state has a 6-week abortion ban. And this is the lunacy that she's coming here and focusing on? Guys, it's over. It's dead. It's rigor mortis. And it's time to move on. I yield back.
Gentleman yields back. Votes have been called on the floor. We have a bunch of them, too. I think like 20 votes. So the committee will be in recess while they're speeding up the time on that first vote. So we will go vote, and then we'll come back and pick up where we left off. The committee stands in recess.
Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute.
Objection.
I reserve a point of order.
Point of order been reserved by the gentleman from California. Without objection, the amendment will be considered. The gentleman from North Carolina is recognized to explain the amendment.
Thank you, Mr. Chairman. On June 25, 2024, just 2 days before this markup, the committee received a letter from the White House stating that the committee's subpoena raises significant separation of powers issues because there are executive branch interests at stake. And I'd like you to bear that in mind. I'll come back to the dating and the timing of all this. June 25, just 2 days ago is when the letter appeared. Almost simultaneously, the White House sent a similar letter to Mr. Zwonitzer's attorney stating that he, for those same reasons, quote, is not authorized to provide any of the president's information, close quote, until the White House has reviewed any production. Mr. Zwonitzer's attorney then transmitted a letter to the committee stipulating, in effect, that he would follow the White House's instruction and not release any responsive information. This amendment addresses the White House's and Mr. Zwonitzer's meritless last-minute delay tactics, and it's here that I want to return to the timing. All this began with a letter from the committee to Mr. Zwonitzer on February 14, 4.5 months ago. The committee's subpoena was issued March 22, 2024. The White House, by the content of the letter they sent, makes clear that it has been in touch with Mr. Zwonitzer throughout. Let me tell you something. It didn't take the White House 3 months to figure out that it was going, that it, if it, whatever, it doesn't have any merit here, but whatever argument it was going to make, that it was going to make that argument. We heard a lot from the minority as this hearing opened on this markup about politics. Well, what you see in the White House tendering a letter to obstruct the committee 2 days before the markup and 3 months after the issuance of the subpoena is a bad faith, dilatory tactic to interfere with the exercise of constitutional authority under the impeachment inquiry resolution, vesting power in this committee. That's exactly what it is. As an initial matter, the White House letter states that the committee's demand is for the, quote, president's information. But the subpoenaed information in Mr. Zwonitzer's possession are not the president's personal papers, but rather Mr. Zwonitzer's materials that he used to write the president's book. Simply put, the responsive materials and information covered by the committee's subpoena belong to Mr. Zwonitzer, and the committee has appropriately chosen to pursue them from Mr. Zwonitzer. No executive privilege protects the subpoenaed materials and information from disclosure. In its letters, the White House failed to put forth any legal authority or support for its proposition that the executive privilege applies to conversations between a former vice president and a private citizen. It's odd for the White House to raise the prospect that the material President Biden discussed with Mr. Zwonitzer could possibly be covered by executive privilege when the president discussed the material with him for the purpose of writing a book, allowed him to keep the material after the book project was over, and apparently did not have any contract with Mr. Zwonitzer requiring him to keep the material confidential. No protection for it at all. Additionally, the White House did not exert executive privilege over the material before it was disclosed to Special Counsel Herr's office. Therefore, any conceivable executive privilege over the material has been waived. And moreover, the White House relies on the Supreme Court's ruling in Trump versus Mazars, except the Mazars framework only applies to personal information about the president held by third parties that is covered by some sort of contractual or statutory obligation of confidentiality. As the committee has explained repeatedly to Mr. Zwonitzer, the Mazars ruling does not apply to the subpoena issued to him. because he has not established that he is under any such obligation, especially since such information was used to write a publicly released memoir. The committee cannot allow the White House to interfere in our actions to carry out our constitutional oversight duties. Mr. Chairman, my time has expired.
Gentleman yields back. Gentleman from California withdraws point of order. Who seeks recognition? Gentleman from California is recognized.
Mr. Chairman, much as I don't like certain parts of the Mazars decision, it clearly applies in this case, and the committee is required to engage with the White House in order to seek an accommodation over materials held by a private party, as they were in the Mazars case, and seek to resolve this with the White House. So I would ask unanimous consent that we enter into the record your correspondence to the White House.
Without objection.
Seeking to engage them to resolve this. And I thank the chairman for not objecting. Can you produce that correspondence to the White House asking for accommodation on these materials you've sought by this subpoena?
First time they reached out to us was 2 days ago.
Yes, and of course the author expressed the concern that these materials may implicate interests of the executive. I think that was weeks ago. But having admitted without dissent your correspondence to the White House, can you produce that for us where you have sought an accommodation, where you've sought to work this out with the White House? Can you share that with us since that is now part of the record?
Well, I thought you had it. You wanted to enter into the record.
I do. I presume that, knowing your responsibilities, you have sought to engage the White House. So,
Mr. Chairman, point of order.
Produce
Gentleman is recognized for point of order.
I think a unanimous consent request to submit something to the record is where the person who's asking for the floor is the proponent of submitting information that member has. I don't believe it's appropriate to ask a unanimous consent request to engage in a colloquy over discovering information or obtaining information from another member of the committee.
Great, and that's why I said that no objection to the unanimous consent request. If the gentleman from California wants to talk about that and present it to us, God bless him. He's allowed to do it. Takes 5 minutes.
I would like clarification from the chairman. Does this mean that there is no correspondence from you to the White House seeking accommodation on this material?
We've had all kinds of correspondence with the White House on this broad subject relative to the Zwonitzer and the letter we got 2 days ago. We've not corresponded with the White House yet. If we will, we may. That's a decision we'll make.
And you have not corresponded with the White House seeking accommodation ever since the author who you are subpoenaing and seeking to hold in contempt articulated the view that there was executive interest and potential privilege over this material. You haven't sought to engage over the weeks since you received that communication?
We have not engaged with the White House since the letter on the 25th of this month, 2 days ago.
And prior to that time, did you engage the White House in an effort to obtain these materials?
All kinds of engagements with our counsel and counsel,
I'm talking about
the Justice Department and White House with our counsel over the last several months relative to the special counsel
this subpoena, Mr. Chairman. Did you engage with the White House at any time in the last several weeks since issuing this subpoena, the one you want to hold this witness in contempt for? Did you ever engage with the White House in an effort to accommodate, an effort to reach an agreement, an effort to prevent this from having to be litigated? Did you ever write any correspondence, make any call to the White House seeking to engage, seeking to get these materials that you're seeking from the author instead from the White House? Did you ever do that, Mr. Chairman?
We're seeking documents from a private individual who I might add tried to destroy the evidence.
I guess the question is, I guess the answer is no. The answer is no.
The answer is since 2 days ago, I have not.
I'm not asking the question about since 2 days ago, although nothing.
That's when they first raised the concern.
Nothing prevented you from writing a letter within the last 2 days or reaching out to the White House before this.
Now you want me to be clairvoyant and read the White House's mind and write a letter before they tell us something?
Nothing prevented you from seeking these materials from the White House.
California is known
for months, Mr. Chairman. For months.
I'm not a mind reader.
And I thank you for making a very clean record for any court that will look at this.
The gentleman from North Carolina said
accommodation
months ago the White House could have raised the concern, and they didn't.
These documents, because your first move, of course, is to go right to contempt. Ironically, of course, for a chairman who was in contempt of his own subpoena.
Point of order, Mr. Chairman.
We're still waiting for you to testify and meet the obligations of your own subpoena, Mr. Chairman. But nevertheless, I appreciate you're making such a clean record for any court in this case that you have never sought an accommodation, never written to the White House, never called the White House, never had a communication with the White House in order to obtain these materials as part of an accommodation. Thank you for that very clean record for the court, and I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. Along those lines, I'd like to point out that this wasn't just raised 2 days ago in a letter from the White House. This was raised on April 12th by a letter from Mr. Zwonitzer's counsel to you. And it said explicitly that the president, these deal with the president's personal papers and personal information. Therefore, the committee should seek the information through the executive branch. So this came up on April 12th. And then in addition to that, as Mr. Herr's report points out, and we've had that for months now, this information went from Mr. Zwonitzer to the Department of Justice. And in fact, some of the information that the chairman referenced, the materials that were deleted, Mr. Zwonitzer wouldn't even have those because they had to be restored by the Department of Justice after they received the computer that he had and used it to try and delete the information. So this is information that the committee should be seeking from the White House and from the Department of Justice and has chosen not to do it. And it's chosen not to bother with the accommodation process too. And that was raised in the letter that the White House sent 2 days ago. But I think it's important to point out that because this is actually a conflict not between the committee and a private citizen, this is a conflict between the legislative branch and the executive branch. We shouldn't just gloss over the fact that you can try and circumvent all of the law that's been put in place by the Supreme Court over the years in trying to address this and resolve it using a process that's informal. It's called the accommodation process. But the Supreme Court has said each branch must take cognizance of an implicit constitutional mandate to seek optimal accommodation through a realistic evaluation of the needs of the conflicting branches in the particular fact situation. Based on the colloquy just between the chairman and the congressman from California, it's clear that hasn't taken place. And I think it's also important to say that even though you got the letter from the White House 2 days ago, that doesn't mean we had to go forward today. In fact, I think based on what we've heard so far, we really shouldn't have. There should have been an effort to try and resolve this by reaching out to the executive branch and or the Department of Justice to get the information that way. And just along those lines, the other points that were raised, both by the White House and by Mr. Zwonitzer raised the issue in his April 12th letter. First of all, the reporter's privilege, which the draft reporter, the amendment in the nature of a substitute, dismisses based on the waiver clause, but I guess we'll have to have a court resolve that because everything seems to be needing to go to courts these days out of this committee because we're abusing, I think, constitutional authority to have contempt power, but we're using it for fishing expedition after fishing expedition in ways that, sadly, I think are obviously political. Because we know Mr. Herr has this information. We know that he did a criminal investigation and concluded that criminal charges were not appropriate here. And we also know that this committee isn't in the business of second-guessing prosecutorial decisions of that nature. And by the way, the case law that's in place says that in this kind of scenario, the information needs to go to the heart of the matter. And I know you guys say it does. We'll set that to the side for the moment. But the party seeking the information must have exhausted every reasonable alternative source of information. And what the chairman just said a few minutes ago is, you haven't even tried. Haven't even reached out to the Department of Justice to follow up on this. Haven't tried to address this by going to the White House and addressing the privilege arguments that are raised. Instead, we're going to rush to judgment here and try and get this done in a heartbeat. I saw a similar matter to this when I was working on the Whitewater hearings. And Mrs. Clinton had written a book called It Takes a Village. The the Republicans subpoenaed the ghostwriter, we didn't go to the ends of, trying to hold somebody in criminal contempt. We used the accommodation process to try and resolve it, and we did. And, I kind of bristle when people call us the lower chamber in contrast to the Senate, but based on the behavior today and the way I think we were abusing our power, I think it's clear that that is the case today. And with that, I yield back.
Gentleman yields back. Who seeks recognition? Question occurs on the amendment to the amendment in the nature of a substitute. All those in favor say aye. Aye. Those opposed, no. No. Opinion of the chair is the ayes have it. Who seeks rec? Roll call is requested by the ranking member. Clerk will call the roll on the amendment to the amendment in the nature of a substitute.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes aye. Ms. Sparks? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Rulli? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Ross? Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no.
Gentleman from Arizona.
Mr. Biggs? Mr. Biggs votes aye.
Gentleman from California.
Mr. Schiff, you're not recorded. Mr. Schiff votes no. Ms. Hageman, you're not recorded. Ms. Hageman votes yes.
Is Ella working on it? We gotta get some people are in oversight.
Mr. Kiley, you're not recorded. Mr. Kiley votes aye. Ms. Escobar votes no. Ms. Ballant, you are recorded as no. Mr. Fry, you are not recorded. Mr. Fry votes aye.
Gentlelady from Florida.
Ms. Lee votes aye.
Mr. Chairman, may I ask how I am recorded?
Ms. Lofgren, you are recorded as no.
Thank you very much.
Anyone else wish to vote? Good, right? Clerk will report.
Mr. Chairman, there are 13 ayes and 12 noes.
13 ayes, 12 noes. The ayes have it. I called the vote. There are 13 ayes, 12 noes. The amendment is adopted. Who seeks recognition? Gentlelady from Washington.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, it's absolutely absurd that we are considering this report today to hold Mark Zwonitzer, President Biden's ghostwriter, in contempt of Congress. My Republican colleagues have already tried to obtain records of the special counsel's interviews with the president from the administration, and the Department of Justice has already given this committee substantial information. The administration has also been clear with my Republican colleagues that they need to engage with the executive branch on this issue. The main story here, Mr. Chairman, is that there really is no story. Special Counsel Hur engaged in an extensive and independent investigation. Mr. Hur found insufficient evidence to prove beyond a reasonable doubt that President Biden willfully retained any classified materials. Moreover, Mr. Hur found insufficient evidence of any criminal wrongdoing and concluded that no charges were warranted. The special counsel noted 11 separate times in this report that he declined to prosecute the president. This is in stark contrast to Donald Trump, who was convicted on 34 felony counts of falsifying business records, becoming the first president in 234 years of our history to be indicted. We have already wasted committee time on a hearing on this report from the special counsel. My Republican colleagues have already issued a subpoena to Attorney General Garland on this matter and held him in contempt of Congress because they didn't get audio recordings on top of the information that DOJ did provide. And now my Republican colleagues are going after a private citizen, a journalist and an author of 40 years, He has never been in the public eye, and I'm disappointed that this is how my colleagues have decided to use our time today. This is nothing but a distraction from the fact that my Republican colleagues have nothing to show for controlling the House. The Republican-controlled House is on track to be among the least productive in the history of this country. In the first half of this Congress, the House only passed 27 bills that became law, even though my Republican colleagues held 724 votes. As some of my colleagues on the other side themselves have said, they have nothing to run on, and it is embarrassing. When Democrats controlled the House and the Senate last Congress, we had one of the most productive Congresses, signing 365 bills into law. We passed transformational legislation that is continuing to make a difference in people's lives, to lower the cost of prescription drugs, cap the cost of insulin at $35, and make historical investments to fight climate change and build a green economy. To date, the infrastructure law that most of my Republican colleagues did not vote for has injected over $54 billion, billion with a B, into 56,000 projects in all 50 states and the District of Columbia. Projects that are improving and strengthening roads and bridges and funding zero-emission transportation to improve air quality for Americans across the country. But that's not the story my Republican colleagues want to tell, especially today as President Biden, who helps advance and sign these historic investments into law, whose leadership was so phenomenal on investing in America, investing in people, building an economy from the middle out and the bottom up. Tonight is the night that President Biden debates Donald Trump. So instead, my Republican colleagues are using their position in Congress to bully a private citizen, to distract from their own shortcomings and the legal troubles of their candidate who has been convicted. First former U.S. president to ever have that dubious distinction. That's the real story here. I yield back, Mr. Chairman.
Lady yields back. Gentleman from New Jersey is recognized.
You know, I didn't prepare anything for this. I don't have a prepared speech, but it just struck me by what was just said as far as, you know, how wonderful everything was under and is under the Biden administration. Record inflation, record high interest rates, open borders, more crime in our cities, war around the world, a military that is literally lacking a lot of the things they need as far as morale. Those aren't good things. And you know, the only thing that is worse than passing a limited number of bills is passing bad bills. You don't judge a Congress by the number of bills that they pass. You judge them by the bills that they don't pass, trying to prevent problems, and you also judge them by the good bills that they pass. And I think you judge this committee by the things we've brought to light. If it wasn't for the majority in this committee, the average American wouldn't know what's going on. And let's go back to the case at hand here with Mr. Zwonitzer. We've asked the DOJ. They brought up before, one of my colleagues on the other side of the aisle brought up that, you know, we should go to the Department of Justice. We have. We've asked for the audio tapes. We got the transcripts, but we didn't get the audio tapes. If there is no problem, why wouldn't you turn them over? Think about it. The audio tapes should be exactly the same as the transcript. But is there a problem? Was the transcript not accurate? I would believe and hope that it is. But is there something in what President Biden said and the way he comported himself and the way that he behaved in those audio tapes? Some of the things maybe he did say or even didn't say that are of concern. We have a right to know that.
Will the gentleman yield for a question?
Just in a second. But we didn't get that information. You know, and here we are again. We ask, I mean, think about it. We were comparing what happened with classified documents with Joe Biden and Donald Trump. Donald Trump was a president when he removed those documents. He was a president that has a right to declassify. He was a president that put it in an area that was safely stored. Joe Biden, you can laugh all you want. I'll tell you what isn't funny is keeping documents in a broken down box next to a collapsed dog bed in a garage. That's not funny. And that's real, and that's where Joe Biden kept the documents. And then what's even less funny is Joe Biden made money on the deal. He gets a ghostwriter, he writes a book, and he uses the classified documents for the book. And I think it was $8 million. I don't have it in front of me. That's what's really concerning. President Trump didn't make any money from keeping classified documents. So we're not declaring like to like, and that's the issue. It is once again, over and over and over and over again, justice for thee. Guess what? Any of us on either side of the aisle, if we were subpoenaed and we're supposed to give information, we would be in trouble. And those other individuals.
Will the gentleman yield for a question?
I will. I said in a minute. This is my time. You already spoke. So the point is, it's just a matter of being fair. If there's nothing to worry about, turn it over. If there's something to worry about, I understand why you wouldn't turn it over. And that's the point of this whole issue. He should turn over, the ghostwriter should turn over the information that he has, the documents that are requested. If they're no big deal, why wouldn't you give them up? It would lead you to believe that there's something wrong, and I believe there is. Now I will yield.
Thank you. I thank the gentleman from New Jersey. Two questions. One is with respect to if you got the subpoena, why wouldn't you just comply with it? Is the gentleman aware that Kevin McCarthy, Jim Jordan, Scott Perry, and Andy Biggs received subpoenas from the January 6th committee and never complied at all?
I'm going to take my time back for a second. A committee that wasn't bipartisan, wasn't legal.
It was, actually.
It wasn't. You had a couple people on there. There was not, you can't say that it was bipartisan. Mr. Chairman, may I have my time? Mr. Chairman, may I have order?
Time belongs to the gentleman from New Jersey.
So we all know that the committee, that Speaker Pelosi at that time refused to have a true bipartisan committee, and that the committee was fake. And the committee didn't do anything. And then afterward, documents from that committee are missing and we can't get a hold of it. There is a history here. This we see repeatedly over and over again. Just because a partisan group of people say a committee is bipartisan does not mean that it is, because that committee was never bipartisan. You had 2 Republicans on there that hated Republicans and the rest were Democrats. Come on.
Gentleman's time has expired.
I yield back.
Gentleman yields back. The gentlelady from Pennsylvania is recognized.
Thank you. I move to strike the last word.
Gentlelady is recognized.
As several of my colleagues here have noted, this resolution to hold a private citizen in contempt of Congress is a waste of the American people's time and our taxpayer dollars. But the truth is, this hearing is, again, a sham. If our colleagues across the aisle genuinely wanted to develop legislation to improve the executive branch's handling of classified materials, then there is much more fertile ground for investigation, which they have thus far ignored. I'm talking, of course, about the gross mishandling of sensitive documents by the twice impeached former president, who has actually been indicted for his failure to secure and his willful failure to return classified documents. Concerningly, as we saw again just this week in court filings, he kept some of our nation's most sensitive secrets in unsecured areas of his golf club, mixed among discarded Christmas decorations, golf shirts, newspaper clippings, and soda bottles. But that's, of course, not what Mr. Trump's allies here are focusing on. Instead, House Republicans have wasted 1.5 years of the American people's time on a vengeful, politically motivated stunt. 1.5 years of investigations, depositions, written testimony, and hundreds of thousands of pages of documents, with none of it turning up any evidence of impeachable offenses by President Biden or his administration. In fact, their star witnesses and supposed bombshell disclosures have been repeatedly debunked, discredited, and disavowed. They've conclusively proven what the world knows, that the current president has not committed impeachable acts. Now, instead of cutting their losses, they continue to double down with increasingly desperate measures like this one, shamelessly bowing to the former president's calls for retribution against his political rivals in a desperate attempt to distract from his felony convictions and prop up his re-election campaign. Faced with failure after failure in their investigations in their legislative agenda and in their ability to actually deliver for the American people. House Republicans are now stooping to new lows. As several of my colleagues have mentioned already, the appropriate remedy here, if they were serious, would be to engage with the administration. But instead, they're choosing to wield congressional power to try to intimidate a private citizen. It's outrageous, it's not legitimate oversight, and it's not what our government is supposed to be used for. I deeply oppose this misleading, partisan, and disingenuous effort to weaponize the Judiciary Committee's oversight authority, and I would yield back.
Lady yields back. The gentleman from California is recognized. Hit the mic there, Mike, or microphone.
Impeachments, and weren't even able to name an actual crime. You are not our teachers. We will follow the evidence wherever it leads, and we'll only bring charges when and if that evidence clearly and compellingly supports them. Now, the House is still investigating whether the Biden family influence peddling scheme directly involved the president, despite all of the obstructions that the administration has erected. It's hard to imagine whose influence other than Mr. Biden's would be worth millions of dollars to hostile foreign governments and interests, but clear and convincing evidence must support the suspicions. I would think at this point that even if that evidence is presented, we should not pursue impeachment, since we are now 4 months from a presidential election, and that question ought to be left to the American people to decide for themselves. Now, contrast that with this administration that for the first time in our nation's history is trying to jail its political opposition, and that a former president of the United States. The Democrats have shattered every political and legal norm to do so. They've made a mockery of the American tradition of equal justice under law, and that very question is what brings us here today. Equal justice under law is at the heart of this subpoena.
Will the gentleman yield for a question?
No, I will not. This administration has made the unprecedented decision to prosecute its opponent, a former president, for mishandling classified documents, in spite of the fact that as president, he had absolute discretion over the handling of such documents, and under the Presidential Records Act has the discretion to decide what records he takes with him when he leaves office. Investigators have already documented that the vice president, Mr. Biden, also mishandled classified documents, but of course he doesn't have these immunities. And yet, this administration determined that Mr. Biden shared classified material verbatim to the ghostwriter. He had no authority to divulge that information. His ghostwriter had no authority to receive it. And yet they chose not to prosecute Mr. Biden, but to pursue the prosecution against Mr. Biden's political opponent. Now, this respondent is a material witness to the divulgence of classified information by the then vice president, which literally defines the case which Mr. Biden's attorney general refuses to prosecute. And we, as legislators, have to understand that decision in every detail, because that then illuminates what needs to be done to restore confidence in this process and assure that the law is being evenly and equally applied without political favor, including statutory changes to affect this result. The radically different decisions to prosecute Donald Trump but not to prosecute Joe Biden by the Biden Justice Department is central to the equal administration of justice, which is in turn central to the rule of law. Without equal justice, the law loses its legitimacy and simply becomes a raw exercise of force. The House Judiciary Committee is charged with zealously guarding these fundamental principles and to craft the laws necessary to protect them. The circumstances that have brought us to this sad period of our history need to be clearly understood from every angle, and then to take whatever legislative action is necessary to assure that this woke lawfare never threatens our democracy again. We have a well-established path available to us, which includes the contempt citations before us right now. This administration has pursued criminal contempt against 2 Trump officials for ignoring a congressional subpoena and had them sentenced to jail for doing so. Should this same administration now refuse to prosecute this case, it raises further questions over the double standard of justice that this administration seems bent on implanting into our system of justice. But we don't need to address those questions today. Today, the simple issue, the crystal clear issue is this: the House issued a legal subpoena over a legitimate and defined matter of legislative significance, and that subpoena has been ignored. Our next recourse is to hold the individual in contempt and refer the matter to the Department of Justice. That's the appropriate response. And it's a fundamental question of enforcing the prerogatives and powers of Congress, and it disappoints me that this vote would not be unanimous.
Mr. Chairman?
Gentleman yields back. The
Gentle-
I think we're on Mr. Ivey, then use, that's what I was, Mr. Ivey? The gentleman from Maryland, excuse me.
Thank you, Mr. Chairman. I have a lot to respond to that popped up there. Just Mr. McClintock's final comments. No, this is not the next step that's supposed to be taken. According to the Supreme Court and court law that we discussed earlier, the accommodation process is the next process, the next steps to be taken. And as the chairman acknowledged in his responses to questions from Mr. Schiff, this committee hasn't done that, hasn't even initiated those sorts of conversations, either with the White House, the Department of Justice, or any other aspect of the executive branch. Furthermore, as you know, I think you did a great job of articulating why this is a conflict between the executive branch and the legislative branch. Why Mr. Zwonitzer gets caught in the middle of that, I think, has not been articulated, and at least not well, especially since all of the documents, all the information that the committee is seeking is in the possession of the Department of Justice. And as I discussed earlier, there's no effort that's been made by this committee to get this information from the Department of Justice. My colleague from New Jersey talked about going to the Department of Justice previously for information, but he's conflating Mr. Zwonitzer's material with the her report material. This committee did have a hearing of sort and did seek contempt with respect to the audio tape from the deposition that Mr. Biden gave, but there's been no effort to try and do anything along those lines with respect to this civilian who's caught in a conflict between, you know, 2 giants that are the executive branch and the legislative branch. And I got to say this too, you know, when we go down this path that quickly, it creates problems that don't need to be there. And I mentioned the January 6th subpoena a few minutes ago, and this kind of a scenario we had in the last Congress. Obviously, that was relevant. In fact, I think it goes to the heart of the one of the cases that are the criminal cases that are standing against Mr. Trump right now. So we can't say that it's an irrelevant matter or that he's not getting his day in court. But the January 6th subpoenas went directly to the information about conversations had with the president and those members of Congress on that day and leading up to that day that were directly relevant to that day. Now, Mr. Klein's not here, but we've had this discussion before, and I know he would say, Mr. Ivey, they didn't just stiff the committee. They actually sent letters in response and raised privileges and objections to why they shouldn't have to comply with the subpoena. And at least Mr. Jordan did. I don't think Mr. McCarthy did. He just didn't show up for his deposition date. But the fork in the road occurs right there, because right now we've got Mr. Zwonitzer, who is trying to raise these kinds of rights and objectives and privileges. The White House raised its two days ago. By the way, Mr. Jordan responded to the January 6th report subpoena 2 days before he was supposed to show up for his subpoena too. So this last minute thing that was raised earlier does not permit us to go forward in this process as we are today. But in any event, rather than step forward and start holding members of Congress in contempt, as I guess would be what we were trying to do today, if the January 6th committee had treated this the same way we're behaving now, that would have been the next step. as opposed to trying to reach some kind of accommodation. In that point, it was referred to the Ethics Committee. But seeking criminal contempt is a big step that we're treating very cavalierly, very cavalierly. You know, we've got a constitutional obligation to conduct oversight, sure, but really? No accommodation process? We get a letter from the White House, and just because we got it, you know, a day or two ago, that means we don't have to try and deal with the issues that are raised in the White House letter? We don't even have to go to the Department of Justice, even though we know they have all of the information that we're trying to get from this private citizen. And the case law that I just read a few minutes ago says that's exactly what we're supposed to do, exhaust all other alternative sources for the information. This is not how we should handle the power that we've been entrusted by the American people in the Constitution. We just shouldn't do it this way. I don't know what the rush is. I don't know why we have to do the hearing and hold this private citizen in contempt today without even trying to take the steps that the courts have told us we're supposed to take. So, I think this is one where, you know, if you want to have a hearing, which is something that I would highly recommend, you know, give them a chance to present their arguments and their, you know, whatever privileges and rights they want to assert. They should have a chance to do it. We shouldn't be doing it on the fly like this. Like like he doesn't have a lawyer that's tried to respond. He sent us a written letter raising these objections 6 weeks ago.
Time of the gentleman has expired. Gentleman yields back. Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. You know, Joe Biden knew that Zwonitzer did not have security clearance. He also knew, Mr. Zwonitzer knew he didn't have clearance. And yet, in the process of all this working on the book, Mr. Biden chose to read and disclose classified information. So I get when our colleagues on the other side of the aisle said Joe Biden was talking to Mr. Zwonitzer, his ghostwriter, about sensitive things. They're right. Classified things that have, many of those entries remain classified even today. And her report is replete with that. Joe Biden says, do you have any idea? This is on page 106. Any idea what the heck I'm saying there? As he hands him a classified document. Mr. Biden then reads the information to Mr. Zwonitzer. Mr. Zwonitzer reads the classified documents and puts it out there. What's interesting to me is when you talk about that Joe Biden's talking about the tragic death of his son, Beau, and we all have respect for that. But there's a whole chapter in Mr. Her's report about the classified Afghanistan documents that Mr. Biden retained and shared with the man without security clearance, Mr. Zwonitzer. And yet, we're told that we need to wait longer. That's what we just heard is don't do it today. You don't have to do it today. Just the fact that for 2 months, about every 7 days, you were having contact and communication with Zwonitzer's attorney, that's not enough. You got to do more. And that's really unfortunate here. But then when we get to the real crux of this with Mr. Zwonitzer, when he finds out what's going on, what does he do? He deletes his information. He destroys evidence. That's what he does. He destroys evidence. And so I find that really intriguing. And when we get down to the nub of this, did Mr. Zwonitzer have the opportunity to actually ameliorate this? And the answer is yes, he did. Did he choose to ameliorate it? No. Could he cure contempt? Maybe he could. He's not indicated any desire to cure contempt at this point. And the bottom line is, ultimately, was he issued a subpoena by a committee, a real committee, that had authority to issue that subpoena? And did he respond to it, or did he say, look, I'm not going to respond? And he said, I'm not going to respond. Well, now...
Will the gentleman yield for a question?
No, I'll yield to you, just like Mr. Swalwell tried to engage in a colloquy where he then always
refuse to take answers.
I always allow people to yield when I'm speaking.
So, you know, Mr. Ivey, you do, and I appreciate that. But the bottom line is, you have a situation here. Subpoena's been issued. There's been discussions back and forth, which in my mind meets what the court said. Then not only do you have the discussions back and forth, he basically says, I'm not going to provide the information. Now you're left. I yield now to the chairman.
I appreciate the gentleman. I want to just reiterate what the gentleman said. I thought he laid it out well. Page 1 of Special Counsel Herr's report, he said Joe Biden willfully kept, willfully disclosed information he knew was classified. He gave that information to someone who wasn't allowed to get classified information. Page 231, the special counsel tells us why Joe Biden did it. He said Joe Biden had strong motivations for ignoring classified procedures because he was writing a book for which he got paid $8 million. So there were 8 million reasons why Joe Biden willfully kept, willfully disclosed information to someone who wasn't allowed to receive it. And then when that individual who received that information, as the gentleman from Arizona just pointed out, when he knew there was an investigation, he tried to destroy it. What the committee is saying, we want the information he tried to destroy, because we think that will help us look at this real concern the American people have about, is justice being administered in an impartial fashion? That's what this comes down to. And I thought the gentleman from Arizona outlined that extremely well. I yield back to him.
Thank you. Now I yield now to the gentleman from North Carolina, Mr. Bishop.
And I would submit that the gentleman from California, as he said, for the reasons he described, that the protestations that come from the other side sort of remind you of the saying, one will gag on a maggot but swallow an elephant. If you think of the recent history of exactly these sorts of things. Be glad to speak to that more, but the time's expired.
Gentleman's time has expired. The gentlelady from California is recognized.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
A lot of incorrect things have been said here, and it's really very challenging to deal with all of them. I will say that as to the January 6th committee, a number of courts considered the question of whether it was properly constituted, and all of them found that the committee was properly constituted. We did issue subpoenas to members of Congress who did not comply. We did not refer those matters to the DOJ, primarily because of Article 1, Section 5, which says that each House should determine the rules of its proceedings and punish its members for disorderly behavior. And we thought that was the more appropriate response rather than referring to a separate branch of government. I think clearly this subpoena this effort does not comply with the rules, with the four-pronged test of the Missouri standard, with the required consultation. It's defective, and therefore it leads me to the strong suspicion that there is a political purpose for this. At this point, I would like to yield to my colleague from California, Mr. Swalwell.
I thank Ms. Lofgren. I can't let go that one of my Republican colleagues just stated that the boxes containing national security secrets that were seized at Mar-a-Lago were stored in a safe manner. Quote, stored in a safe manner. This is the bathroom at Mar-a-Lago with over a dozen boxes of national security secrets that were stored in a safe manner. My friends, you are living on Fantasy Island. That's where cults live, so that makes sense. But this bathroom is a mess. This committee has been a mess, and this Congress is a mess. This is not stored in a safe manner. It's delusional to say that. But let's talk about the witness you're seeking to hold in contempt today, because that person is a ghostwriter. That's where we have now landed in this long investigation. We're going to hold in contempt a ghostwriter. And why are they seeking a ghostwriter? Because they have literally run out of people to support their baseless, false, completely meritless allegations. I'll walk you through some of them. We saw in this committee, Durham. Mr. Durham was brought here. He was appointed by Donald Trump, kept on by the Biden administration, and he brought 0 indictments against any of the people you alleged had done anything wrong. Then we had Mr. Herr, who was appointed by President Trump, kept on for the investigation of the mishandling of classified documents by the Biden administration and said there was zero legal wrongdoing by President Biden. You wouldn't let Hunter Biden testify in public. You did it in a secret location that the public was never able to see. That transcript didn't go so well for you, so you never brought him back in public. Then you had Devin Archer testify, and he said that there was no evidence of wrongdoing by Joe Biden. You brought in Tony Bobulinski, a person who would best be remembered for suing his cancer-ridden father's charity. Then there was Alexander Smirnov, who had the smoking gun about all of the Biden corruption. He's not available because he has been indicted for being an agent of the Russian government. There was Mr. Gall Luft. I'm sorry, he also can't be here today to help you because he was indicted for being a Chinese agent. Then my favorite, and you could say this is when you jumped the shark, is when you had Jason Galanis testify from prison. You zoomed a guy in from prison to try and support your investigation. Guys, in baseball, you get 3 outs and the inning's over. In football, you get 4 downs and then it's over. You're out of outs, you're out of downs. And as far as we're concerned, President Biden has been acquitted and it's game over. And I yield back to Ms. Lomford.
Thank you for yielding back, and I yield back, Mr. Chairman.
Gentlelady yields back. Gentlelady from Florida is recognized.
Thank you, Mr. Chairman. As we've sat here today, we've listened to our colleagues on the other side of the aisle have a lot of descriptions for this hearing. It has been referred to today as a sham, as a waste of time, as a political stunt. The motives of the members of this committee and the purpose for this hearing have been impugned over and over again, and it could not be further from the truth. First, let's begin by reviewing the reality of the report of Special Counsel Hur, and it was not an exoneration of President Biden. It certainly was not an acquittal of President Biden in any sense of the word. In fact, it was the opposite. That report presented evidence, presented conclusions that not only did President Biden possess classified documents that he was not lawfully entitled to have, that he handled them carelessly, that he shared them with others who were not entitled to understand or see or be aware of the contents of those documents. It did not conclude that President Biden acted properly. In fact, it concluded the opposite, that President Biden acted in a way over and over and over again that is contrary to our law, reckless, and contrary to the interests of our national security. What did the special counsel conclude instead? That President Biden might not be convicted by a jury because he would be perceived as a well-meaning, confused, elderly man. That is the conclusion of Special Counsel Hur. Not that there wasn't wrongdoing, but that a jury might be so taken by the confusion of a well-meaning elderly man that it would choose not to convict. And so what brings us here? The good faith efforts of this committee to identify the truth and the facts of what went on in those interviews with those documents, who saw them, what does this mean for our country? What risk has been posed to us because a president of the United States chose not to handle these documents correctly? There is a not only valid, a vital purpose to this hearing today. Moreover, when we serve a subpoena, we're just looking for compliance. And all of this about this witness and an opportunity, he's had opportunity after opportunity after opportunity to comply. And so now we have a report in front of us that recommends a finding of contempt, and as we should. Not only should we find him in contempt, that we should be unanimous about the fact that there has been a lack of compliance, and contempt in this circumstance is warranted. And with that, Mr. Chairman, I yield to the gentleman from North Carolina.
I thank the gentlelady. I'm struck by, as I said earlier, the saying, and I think people will say it, you gag on a gnat but swallow an elephant. You're concerned about fine points of what Mazars requires in terms of an accommodation process when personal information about the president is sought and how that accommodation process should occur. But you spent years trampling every norm in sight in ways that would be unimaginable. Steve Bannon, who is scheduled to report on July 1, would be interested at your solicitousness for a private citizen, long out of the picture, who, and in this case, is a firm record that he got classified information disclosed to him. So would Peter Navarro as he sits in jail. Remember that measures arose because Democrats relentlessly pursued purely personal transactional business information about President Trump in the hands of his bookkeeper, basically, for contrived legislative purposes that were transparently political. I wonder, and as the gentleman from California aptly put it, unprecedented in American history for a major political party in control of the Justice Department to work assiduously and with great urgency, pointing at timing in relationship to the upcoming election in which their political opponent stands as the object of prosecutions across the board. And they want to make sure they get tried to maximize their political opportunity from it. And then they want to talk about the White House. We should stop everything for the White House that shows up 2 days before a hearing on a resolution to enforce contempt. It's unbelievable. I yield.
Gentleman yields back. The gentlelady's time has expired. Is there further discussion on the motion? Mr. Cohen.
Mr. McClintock, I have great respect for you and fondness for you and regard for you. For that reason, I will not say what I think about your statement today. It was not prime McClintock. But this hearing, and I will give credit to Fielding Mellish, who originally said this. Fielding Mellish said, in essence, this hearing is a travesty. It's a travesty of a mockery, of a sham, of a mockery, of two mockeries of a sham. And that's what this hearing is. Fielding Mellish said it many years ago. He said it well. I'm amazed at what we've been talking about today. But I have an amendment at the desk, and that's more pertinent, I think.
Clerk will report the amendment. The gentleman from Arizona reserves a point of order.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives.
Without objection, the amendment will be considered as read. The chair recognizes the gentleman from Tennessee for 5 minutes.
Thank you, Mr. Chair. This amendment would place at page 4 between the first and second paragraphs the following language. And facts. There are serious concerns about the audio files that may be manipulated for political purposes. They want audio files. They don't need transcripts. They want Notably, in recent months, Republicans have repeatedly circulated deceptively manipulated, cheap, fake videos targeting President Biden. For example, after President Biden appeared at a D-Day commemoration ceremony in France, where I and several people from this, I think from this committee were there, but lots of people from Congress, they showed social media users circulated deceptively edited video that appeared to show President Biden attempting to sit in a chair that did not exist. However, the full video of the event shows there's a chair behind Mr. Biden, which he was promptly sat down in. On June 13th, the Republican National Committee's RNC research account, which is a fallacious name, I guess, a misappropriated name because it's not research, tweeted a deceptively edited video that appeared to show President Biden wandering off following a paratrooper demonstration during the annual Group of Seven summit in Italy. However, the full unedited video shows the president walking toward the group of paratroopers who just landed, giving them a 2 thumbs up commendation. Judiciary Republicans have even circulated their own misleading clips on social media in recent weeks. On June 18th, the official House Judiciary GOP account falsely claimed that Biden fell asleep during a performance by Andrea Bocelli at the G7 summit. I'm sure many other people would have fallen asleep as well, and maybe I would have as well, but the full video shows the president just briefly closed his eyes while listening to Bocelli sing. These and other examples create serious reason to be concerned about how Republicans and others might use highly personal information they are seeking today. There is no need for these audio tapes. We've had the Republican-appointed Mr. Hur come in and say there was no crime committed. And the fact that he said that, and he said it was because a sympathetic figure was shown by President Biden, and the jury probably wouldn't have convicted him, that's still, you're not convicted and you haven't done anything if the jury doesn't find you guilty. There has to be guilt beyond a reasonable doubt, and Mr. Hur, a Republican, whom Mr. Garland kept on as the prosecutor here, the investigator, said that they didn't believe they could find and prove a case. That's what a prosecutor does, and Mr. Garland did the right thing by keeping politics out of it, and Mr. Hur did the right thing by doing what he thought was the right thing as an attorney. And here we are, and we're comparing Mr. Biden's 1 or 2 records that he had and immediately turned over to the federal government to Mr. Trump and hundreds of records stored in his bathroom and which he refused to turn over even after subpoenas, and they had to go in and get him. And then he claimed that the FBI was trying to kill him. That the FBI was trying to kill him. The FBI was just given instructions, as all FBI agents are, when you're executing a warrant, to not kill somebody. The limits of deadly force, the same limits they were told about when they went in to serve and find President Biden. So, it's just absurd, and that's why Mr. Smith is asking for some type of a judicial declaration to protect FBI officers from being subject to harassment and maybe targeting because some crazy person that thinks that Mr. Trump's life was endangered when it wasn't, of course. They knew he wasn't even going to be at Mar-a-Lago. He was going to be at somewhere else. He was in Bedminster or wherever, visiting his wife's grave, which gives them a tax deduction in perpetuity on the golf course. Slick move that was. To compare any effort to impeach the Biden family for what President Trump did by telling Zelensky, you give me the goods on Hunter Biden and I'll give you the weapons. I mean, that's impeachable and should have been. He just didn't have a jury that was politically willing to face the facts. And the same thing for trying to overthrow the government in the second impeachment trial, where about 7 or 8 or 9 Republicans did vote for conviction, but not the 16 that were necessary. And even Mr. McConnell, who said he'd done wrong, didn't have the guts to vote the truth. So regardless of that, Fielding Mellish is here with us today, and this is a travesty of a mockery of a sham, of a mockery of a, et cetera. I yield back.
Gentleman yields back. Is there a discussion on the amendment? Chair recognizes the gentleman from does the gentleman from Arizona withdraw his point of order?
Withdraw my point.
Gentleman withdraws his point of order. Chair recognizes Mr. Issa.
Thank you. I know that this debate is going to go well into the afternoon and perhaps evening. I know it's going to be filled with inaccuracies and one-sided truths. I also know that if the shoe was on the other foot, my friends on the other side of the aisle, including Mr. Cohen, would clearly be saying different things. Because I've been here long enough to know that when a shoe was on the other foot, they took the exact opposite position. We're here to do some serious work of the people, and particularly I want to thank the chairman for holding our branch in a responsible position and demanding that we meet our constitutional responsibilities and that we not simply abrogate authority to the executive branch. That isn't what our founders wanted us to do, and it isn't what my Democratic friends did during the Trump administration. So for those who continue to try to delay this into the evening, perhaps even missing the debate between the two presidential candidates, I say shame on you. Let's do the people's work. Let's assert the power and the responsibility we have as Article 1, as the overseers of an administration, and let's move on. Let's do what we would do if the shoe was on the other foot. And Mr. Chairman, thank you again for sticking up for Article 1 for Congress. And with that, I would yield back.
Gentleman yields back. The question occurs on the amendment from the gentleman from Tennessee. All those in favor say aye. Those opposed, no. No. In the opinion of the chair, the noes have it. Who seeks recognition? Gentlelady from Georgia is recognized.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will report.
Thank you.
Reserve a point of order.
Gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a
Without objection, the amendment will be considered as read. The gentlelady from Georgia is recognized to explain the amendment.
Thank you, Mr. Chair. I brought my amendment to this committee today because I believe in the First Amendment, and this committee should be committed to recognizing and respecting the rights of journalists. We cannot pick and choose when we want to abide by the rules and when we want to bend and break them. This political witch hunt has already cost the American people millions of tax dollars. And I implore my colleagues across the aisle to accept that there is no evidence supporting an impeachment or criminal offense committed by President Biden. How is this contempt resolution for Mr. Zwonitzer the best use of taxpayer dollars? It most certainly is not. There are a million other issues that we could be focused on today in this markup that will make a positive difference for our communities, but we could be talking about gun violence prevention, criminal justice reform, or we could be talking about commerce protections. Instead, we are here to undermine First Amendment protections. Almost a year ago to date, members of this very committee sat in this very room protecting journalists from disclosing records, contents of communication, documents, and information gathered and created in the course of their work when the federal government tries to compel them. That same bill, which received unanimous consent in this committee, then went on to pass on the House floor. Mr. Zwonitzer is a journalist, plain and simple. That is all that he is. He was working in his capacity as a journalist while working as a ghostwriter for the president. And according to this committee's votes at last year's markup, Mr. Zwonitzer is an innocent man who should not be subjected to this political circus. Last year, this committee, in the need to protect journalists, we did that. We worked last year to protect our journalists. What happened? What's happened since last year? Have we decided that a candidate is more important than the rights our Constitution affords us? I surely hope not, because we're all going to lose if we sacrifice the very rights that we claim to hold so dear and so high. Today, I am urging this committee to show that it is not a hypocritical one. Please don't be hypocritical in front of the American people. The powers of this committee are strong and should not be used only to protect the rights of some members that they have deemed as friends. To hold Mr. Zwonitzer in contempt today, those who vote in favor of this resolution will show the American people that you are willing to play with the rules and show an empty hand. Freedom of the press is protected whether or not we like what is being reported. Let's not make a mockery of the First Amendment in this committee today. This committee needs to respect Mr. Zwonitzer's right not to turn over his source material, and I yield.
Gentlelady yields back. Gentleman from North Carolina is recognized, and I'll come back.
Thank you, Mr. Chairman.
I beg your pardon. You called Mr.
I withdraw my amendment.
Thank you, Mr. Chairman. The reporter's privilege is not remotely applicable to the circumstances at hand. First of all, what reporters are mainly protected from in the case where it would apply is disclosing their sources. In this case, the president may not know who Mr. Zwonitzer's source was, but everybody else does. It was the president. He was the one who read verbatim to him from classified information. Moreover, Mr. Zwonitzer may have acted at times in his life as a journalist. He was not acting as a journalist now. The reporter's privilege does not take people who have functioned as journalists at one point or another and set them apart as exempt from the ordinary processes of law applicable to every other American. It is very specific. Reporters are entitled to the reporter's privilege when they were engaged in news gathering. Mr. Zwonitzer was not doing that. He was speaking with President Biden to help President Biden write a book. He was a scrivener for President Biden. So it's irrelevant whether he may have been a reporter in some other circumstance. There is no remote connection between the reporter's privilege and the circumstances at hand. And therefore, be no hypocrisy in pursuing enforcement of the subpoena. And with that, I yield to the gentleman. Well, I think first to the chairman.
Well, I was just going to add one other fact. The government already got the information. Notwithstanding, he tried to destroy it. The government's got the information. They went and got it off the computer. So the part of the government that's got it's the part of the government that can prosecute him, for goodness sake. I yield back.
Another great point. And I'll also yield to the gentleman from California, Mr. Issa.
I thank the gentleman for yielding, and I'll be brief. The claim that this committee, which has protected the First Amendment as one of its most primary responsibilities, is patently simply not true. I think the most important thing that we decide here today is, will we assert the committee's jurisdiction? And that's what we're doing. Again, this committee held, for example, Harriet Miers in contempt for not showing up. She was the attorney to the president. Why did we do so? Were we ignoring attorney-client privilege? No. But actions had been taken that were not covered by it, and we sought to have the information. So I think I heard the gentlelady on her amendment. I can't begin to understand how she could conflate that, but I will predict here today that if the shoe is on the other foot in the future, she will make the opposite decision. And that is something that you should be ashamed of. Were the shoe on the other foot? By the way, just so you know, this committee, or the January 6th committee, held people in contempt and actually has incarcerated them for not being willing to say things about conversations with another president. And you know what? Those people wrote books too. And with that, I thank the gentleman and yield back.
And I thank the gentleman. I again yield to the chairman.
I'm good.
Okay. Well, it's very simple. I mean, it's a little bit reminds me of the White House's bad faith in showing up with the whole idea 2 days before the hearing. It is a contrived defense. This objection is so utterly frivolous legally as to call into question the good faith with which it is offered, and I yield time back.
Gentleman yields back. Question, gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you. This markup is so shameful. It's craven, actually. I'm appalled that here we are again with a desperate Republican Party. Does nobody on the other side of that aisle regret what you are doing today? Does nobody see the shame-filled behavior? If you want to learn about President Biden's love of his family and his loss, read the book. Don't go after a ghostwriter. With that, I will yield the gentlewoman from Georgia my time.
Thank you so much to the gentlewoman from Pennsylvania. And talking in response to what was just mentioned, the bill that you actually voted for, in favor for, has a definition that would qualify Zwonitzer as a journalist in his capacity writing Biden's book. That was H.R. 4250, the Press Act. And the term covered journalist means a person who regularly gathers, prepares, collects, photographs, records, writes, edits, reports, investigates, or publishes news or information that concerns local, national, or international events or other matters of public interest for dissemination to the public. And I yield back to the gentlewoman.
Gentlelady yields back. The question occurs on the amendment offered by the gentlelady from Georgia. All those in favor say aye. All those opposed, no. No. Opinion of the chair, the noes have it. The roll call being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? No. Mr. Fry votes no. Mr. Ruley? No. Mr. Ruley votes no. Mr. Nadler? Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Schiff? Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Ms. Ballant?
Clerk will report.
Mr. Chairman, there are 9 ayes and 13 noes.
The amendment is not adopted. Question. Oh, I'm sorry. Go ahead. Wait.
The vote was closed.
Okay, the vote was closed. I'm sorry, I did not see. We've had this happen a couple of times. Question occurred. Oh, Ms. Dean's got an amendment? Okay, I'm sorry. Gentlelady from Pennsylvania is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment.
I reserve a point of order.
Point of order
Trigger
reserved by the gentleman from
substitute.
California.
To the committee report.
Without objection, the amendment will be considered as read. The gentlelady from Pennsylvania is recognized to explain her amendment.
Thank you, Mr. Chairman. Mr. Chairman, I do have to say I am once again saddened and appalled that this body and my Republican colleagues want to somehow capitalize on the worst personal tragedy that anybody in this place could imagine, the loss of a child. It is simply craven what you are pursuing today. Why are you doing this? It would seem you're doing this because of the 2 men who are involved. You don't like President Biden because he poses a political threat to your favorite felon. So they attack Biden. It's cynical, but hardly new. Now you are going after Mr. Zwonitzer simply because you are desperate. You have the weight of the government, the control of this committee. Mr. Zwonitzer is a private citizen, a writer, a journalist, trusted to convey the most private memories of a father losing a son. In Promise Me, Dad, President Biden describes the moment he knew Beau Biden would not recover, the moment Beau's breathing slowed, the moment his heart stopped beating. Finally, in his own words, he writes that his son was gone, quote, May 30, 7:51 p.m. It happened. My God, my boy, my beautiful boy. I can only imagine that Promise Me Dad has brought solace to so many of us who know grief and loss. Mr. Zwonitzer illustrates these sensitive memories with respect and dignity, a far cry from the tone and tenor of this hearing. By demanding these files, Republicans are intruding on the most private personal recollections imaginable, and they are trying to bully Mr. Zwonitzer into helping them. What does this terrible precedent mean for future writers? Who will want to work on a sensitive subject matter and tell meaningful stories if they have no control over the conversations they had? Even more cynical, why, Chairman Jordan, are you prying into these private conversations at all? Mr. Zwonitzer already produced all the information he is seeking to Special Counsel Hur, a Republican and a former Trump administration appointee. I ask every member of this committee to stop now and really consider, why are you doing this? Is the other side incapable of decency? So, I offer an amendment. My amendment clarifies that the only possible legitimate purpose of this committee, and therefore this contempt resolution, is legislative decision-making. That's what we're here about. The purpose must not be to bolster Republican candidates' chances of victory in the 2024 election cycle, nor to seek embarrassing information about President Biden. Finally, my amendment would require that any audio files must not be released to the public, 2 points, not be released to the public, nor used in any campaign materials by members of Congress seeking re-election. Therefore, I urge my colleagues, based on what must clearly be their intent, nothing political in what they're intending here, only legislative, I urge my colleagues to support my amendment or else admit this is purely political. And I yield back.
Gentlelady yields back. The gentleman withdraws his point.
Even though it was just the opening statement being reread, I will withdraw my objection.
Yeah, the gentleman withdraws. The gentleman from Arizona is recognized.
Thank you, Mr. Chairman. So you want to know who is craven, shameful, despicable? It is you, Democrats. Because here's the deal. We're not asserting anything with regard to Mr. Biden's book or how it came out or anything regarding to his son. What we're talking about is the information that he decided to reveal, which was classified and rated secret, that still remains classified and secret. You have made it about President Biden's son's tragic death and their relationship. We've not inquired into that. We're inquiring into the classified documents and information that he retained over a 50-year career in the Senate and as vice president, and then that he disclosed, in turn disclosed to someone that he knew did not have classification status. It is you who have attempted to turn this into something that it is not. That is craven.
Would the gentleman yield for a question? Would the gentleman yield for a question?
Would you please not interrupt me?
No, I simply
If it
asked,
is,
will you
please
yield?
don't interrupt me. If it is,
Lack of decorum.
yes, you're right, you have lack of decorum. If this is about what you claim it is about, then why did President Biden take $8 million for it? Wouldn't that be craven? The reality is, we're not asking about that. We didn't bring it up. You did. You did. We are asking for information that Mr. Zwonitzer uniquely has, and it's related to his receiving sensitive classified information from a former vice president, former senator, who had no authority but knew he had retained these documents and then disclosed those to this person who was not a journalist, but was a ghostwriter in this instance. That I'll yield to the gentleman from Wisconsin, Mr. Tiffany.
Yeah, to the gentleman from Arizona's point, what we're seeing is a bit of a form of the heckler's veto, where you shout people down in order to suppress discussion, and in this case, to suppress important information that the American people should have before them. And I understand why the other side may want to do that, because they don't want to see this go public, because who knows what information may come out. But we will not be stymied by the heckler's veto. We will follow the information that we are legally allowed to have, and we will attempt to have the Biden Department of Justice comply with the law. I yield to the gentleman from Arizona.
Thank you. I yield to the gentleman from North Carolina, Mr. Bishop.
I think you, Mr. Biggs. In fact, I appreciate the point just made by Mr. Tiffany, that this seizing upon the deeply personal, private, agonizing personal experience in the death of Joe Biden is sought as a form of a heckler's veto, but it's actually more despicable and craven than that, because what you don't even think about, if this is not present to your mind about why we're pursuing the information in the first place, you fail to recognize President Biden already decided to expose that to the public. It is the core of the book, as they just said. So when we go to say, we want to know what all the detail is concerning President Biden's reading verbatim from classified information about Afghanistan to the ghostwriter, the Democrats, with a unanimous repetition from the ranking member on through everyone's comments, says, well, how could you? This is despicable and craven. It is so cynical, the exploitation of that, when the information that you're specifically referring to, President Biden decided voluntarily to write a book about in exchange for $8 million. Wow. You guys, as Andy Griffith used to say, you guys beat everything. You know that? I yield back.
I yield to the remainder to the chairman.
I'm fine. The gentleman yields back. The gentlelady from Texas, and then we'll come to Mr. Ivey.
Thank you, Ms. Chair. I'd like to yield my time to my colleague, Ms. Dean.
And I thank you. Well, all of what was just said reveals that we've struck a nerve over on the other side, and so I'm well aware of that. What you have done here is craven. I might even pull out pusillanimous just to have some fun. But here's my question. The people who have spoken against this amendment, probably you're in favor of it, because my amendment simply says this: therefore, if these audio files are obtained by the committee, no portion of the audio files shall be released to the public or used in any campaign materials by members of Congress seeking re-election. Are you all in agreement? It seems like you must be. I yield back.
Thank you, Ms. Dean. And I'd like to thank you for your amendment. I am in full support of your amendment. I think it would demonstrate by our colleagues on the other side of the aisle, if they were to support your amendment, it would demonstrate that nothing about this effort is political, that it is serious fact-finding. If they oppose your amendment, then it would clearly be an admission that this is purely a political exercise. So makes perfect sense to me, very straightforward. Would you like more time?
And I thank you. I thank the gentlelady for that support of my amendment. And I'll remind everybody, anybody who's still paying attention to this, that all of the information Mr. Herr has. So why they're going after this private citizen, I'm sure it's baffling anybody watching on C-SPAN. Craven.
Thank you, Ms. Dean. Mr. Chair, I yield back.
Gentlelady yields back. Gentleman from California.
Thank you. I move to strike the last word.
Gentleman's recognized.
I'm going to ask a few questions and answer them myself because it may be the most efficient way to get the thought out. You know, Mr. Issa, isn't it true that knowingly receiving classified information that you're not cleared for is a crime? Yeah, I think so.
Objection to the form of the question. Somebody has to represent you in this scenario.
Isn't it true that, that in fact, giving out classified information you've received in a classified format is a crime? Well, yes, it is. Isn't it true that the Vice President of the United States is not entitled to declassify information? Yes, it is. Is it also true that a senator is not allowed to take and keep and declassify information on his or her own? Isn't that true? Yes, it is. I could keep going with the yes, it is, as though I was a cooperating witness, which I am. But trying to bring a little humor to this moment, folks, there has been a serious allegation that a series of crimes were committed for which the elderly man with a bad memory is not being charged. And we still have the responsibility to look at whether crimes were committed. By the way, this ghostwriter probably did commit a crime by knowingly sharing in classified information and hasn't been. Now, if the Department of Justice is going to overlook crimes and only they can, in fact, bring charges, it has never stopped this committee from looking to see whether there are crimes and re-presenting them to the Department of Justice for reasons that they should enforce. But also, quite candidly, we have some other real reasons to do it, but the most important one, quite frankly, I made out trying to have a little humor, maybe a little too much humor, but we are looking at some serious things that went on. I do think that the question of President Trump and the classified documents that are alleged that he had and whether he had declassified them or not is a legitimate question. But I equally consider the questions and answers I just made as worthwhile and important, and I would urge my colleagues to move away from the idea that this has only a political purpose, when in fact, no matter who is in the majority, no matter who's in the White House, we have a reason to support knowing whether or not classified information has been inappropriately shared. And with that, I'd yield to the chairman.
I'm good.
And I'm sorry, I'd yield to Mr. Fitzgerald.
Thank you, Mr. Issa. I mean, this is one of the things that's been driving me crazy since the special counsel was before the committee. And it's this idea that the American people have no right to hear the tapes. And now, in the discussion we're having here today, I find myself kind of bewildered that this, the ghostwriter is somehow characterized as this babe in the woods who was sitting there taking notes based on what President Biden was telling him. If you look back at the record, February 14, 2024, approximately 6 days after the release of the special counsel J.Res report, the committee sent a letter to Zwonitzer requesting 6 categories of documents and records. On the letter's return date, February 23, 2024, Zwonitzer's attorney contacted the committee and requested the committee staff contact him to discuss the committee's request. He lawyered up. This guy lawyered up. And I think the reason he lawyered up is what Mr. Issa just referred to as this idea that there could be classified information floating around out there. And a ghostwriter has his hands on it right now. And then on February 26, 2024, during which Zwonitzer's attorney represented that, he says, I can't be there because of a personal trip. Wow. No sense of urgency, really not replying to the committee, not really concerned about meeting any of the deadlines. And then he was supposed to produce this stuff by March 8th. And then guess what happens? He doesn't do it. So, I mean, the idea that the committee was not doing the due diligence to try and work with this person, and then ultimately when he lawyered up, work with the attorney, is just ridiculous. It's just ridiculous. And now we sit here having this larger discussion about the tapes themselves. The American people should be able to hear about them. When the U.S. House of Representatives has had as much discussion as we have had about this topic, the idea that these are being withheld, not the members of Congress, it's about whether or not the American people should be able to hear these tapes. And it's not necessarily going to be used for political purposes. I think a lot of us feel that, quite honestly, it's just something that should be disclosed. And I wish that would happen. Yield back.
Yeah, gentleman yields back. The chair now, I would just add, he may have lawyered up because he tried to destroy evidence. That might have been why he lawyered up. Gentleman from Maryland is recognized.
Well, this is disturbing at several levels, people seeking counsel. I mean, you know, I sit on the ethics committee, and there are, I can't name any names, but there are members who have matters before the ethics committee, and they're represented by counsel. And
gentleman yield?
I'll say this too.
Gentleman yield?
Yes.
That's fine. I think everyone, if they want a lawyer, should get a lawyer. I'm just saying why he may have done so.
Well,
The gentleman raised that point.
Just to reclaim my time, the gentleman who spoke just before you, and you, by what you said by implication, are suggesting that the fact that he would retain counsel suggests that he's guilty of doing something. And just a few minutes ago, when I raised the point about members of Congress, some of whom sit on this committee, who declined to
Would the gentleman yield?
comply, let me at least finish the statement,
Okay.
comply with the January 6th subpoenas that were received, many of them retained counsel. And by the way, the D.C. Circuit Court of Appeals says that there should be no negative implication drawn from somebody retaining counsel. And if you think about it, if you're just a regular citizen and you get a subpoena from the United States Congress, you might think you're in over your head. You know why? Because you probably are. And this is a guy who, you know, as they say in The Godfather, this is the profession that we've chosen. We've chosen to be in the public light. But this guy's a ghostwriter. By profession, he's sought to stay out of the limelight. And here we are going to hit him with a contempt and suggest that the fact that he got an attorney to help him walk it through it means he must be guilty of something. And then just before I yield to the chair, I got to say this too. It's not like he didn't respond at all to the subpoena. His attorney wrote a letter to the committee 2 months ago almost, raising the exact same issues that the committee really hasn't dealt with, and has said, well, we only heard from the White House about it 2 days ago. But the executive privilege issues were raised in his April 12th, 2024 letter, which I moved to make part of the record by unanimous consent.
Objection.
And he also raised the reporter's privilege, which has been barely addressed, really not at all, by the committee in its rush to move forward with this. The committees have said, you know, he waived it, but, you know, as the White House letter pointed out, and the Mazars case was, you know, cited in support of that, he hasn't necessarily waived it. And we really haven't tried to resolve it here. The committee's just trying to blow past it. My Republican colleagues really don't want to hash it out. They just want to move on and get it done before whatever happens at 9 o'clock happens tonight. So, you know, I want to ask us to be careful about how we move forward with this and the precedent we set. And then with just a little bit of time I got left, you know, the case in Florida against President Trump, there are provisions in here, it's paragraphs 33 and 34 of the indictment. On July 21, 2021, when he was no longer president, Trump gave an interview in his office at the Bedminster Club to a writer and publisher in connection with a then forthcoming book. 2 of Trump's staff also attended the interview, which was recorded with Trump's knowledge and consent. Trump stated, I'm jumping to paragraph 34, look what I found. This was senior military officials' plan of attack. Read it and just show it. It's interesting. Later in the interview, and it goes through a colloquy between Mr. Trump and the staffers on these things, but, you know, based on what the committee's doing today, I suppose, we should be seeking a subpoena against whoever this ghostwriter was for Mr. Trump. And if he doesn't comply, I guess the way the committee would go is you seek to hold him in contempt. I don't know that that's the path we need to go down, especially when there's live litigation going on with the matter. All I'm saying is, can't we just kind of pause and think through about what we're trying to do here and why we're trying to do it? And Ms. Dean's amendment, which nobody's really spoken much to, I mean, why wouldn't we have language in there that says we're not going to use whatever we get for political purposes? Isn't that, I mean, if you're saying the legitimate basis for seeking this information, and you have to if you're seeking criminal contempt, it can only be for non-political reasons, why wouldn't you want to say that in the report?
Gentlemen, yield?
I will yield.
Is there precedent for it? So when committees on the Hill sought the tax returns of President Trump, his business records from Mazars, did they include, make sure?
Go Go ahead. Yes, go ahead.
I think that's enough of a question.
I don't know what process.
I think we need to know.
Well, I don't know what process the committee went through for that. I don't know if there was an effort at subpoena accommodation and then contempt. I don't know. But I know what's happening here today with a third party, private citizen. None of this is required because the Department of Justice has all of the information you're saying you need. I yield back.
Gentleman yields back. I would just point out, I think you're making our point. If what you said really did, I mean, you allege it, I don't know that it happened, where President Trump gave information to a book writer, just like President Biden did, you're making our point. President Trump's getting charged. President Biden isn't, for goodness sake. That to me is a huge, I don't know that happened. It's been alleged it's happened. We know he's getting charged. We know this happened. Special Counsel Hur told us it happened. Joe Biden said that he gave classified information to his ghostwriter.
Will the gentleman yield?
Sure.
Well, Mr. Zwonitzer is not a defendant in this. He's not. Well, by the way, you guys have alleged basically that you think he committed criminal acts.
I've not alleged that. I'm saying what
you did actually.
Reclaiming my time. All we're saying is what Special Counsel Hur sat right there at that table and told us, Mr. Ivey. That's what we're saying. It's in his report. It's in his report. He tried to destroy the evidence. They were able to recover it, they chose not to indict.
That's right. And if you think there's a Fifth Amendment claim there, is it really appropriate for the committee to be seeking to hold him in contempt for not complying with the subpoena? I don't think so, but I'll yield back.
I yield back. Who seeks recognition? The gentlelady from, well, I'll yield to you then. We got 3 minutes, 41 seconds. Go right ahead.
I just want to, before we get to a vote on this, correct the record of what a couple of the folks on the other side of the aisle said, that they were only interested in the reading of classified documents. But really, let's take a look at literally the listing that this committee demanded. According to advance our oversight, please produce the following documents and information. All documents and communications shared between you and President Biden or his staff or representatives relating to your ghostwriting, on and on. All contracts or agreements relating to your ghostwriting. All documents evidencing payments to you relating to your ghostwriting. All audio recordings, not just what might connect to possible classification. All audio recordings of interviews or conversations between you and President Biden. All transcripts of any interviews or conversations between you and President Biden. All documents and communications between you and President Biden or his staff.
That's what we asked for.
Yes, except members of your committee, your side
That's
of the committee, tried to mislead the public and this markup into believing it was, we just want to take a look at what was the classified
We've been clear.
Ask the ladies the words be taken down.
We've been clear. We've been clear. 6 categories of information, documents and information we sought. That's what we've sought. The gentlelady stated that. God bless you for stating what we all know we asked for. I yield back. Who seeks recognition? The question occurs on the amendment from the gentlelady from Pennsylvania. All those in favor say aye. Those opposed, no. No. Opinion of the chair, the noes have it. Court of vote being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Mr. Moran? Mr. Moran votes no. Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Ruley? Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Chairman, there are 8 ayes and 13 noes.
The amendment is not agreed upon. Gentlelady from Texas.
Thank you, Mr. Chairman. I have an amendment at the
Report.
desk.
Reserve a point of order.
Gentleman from California reserves point of order.
Amendment to the amendment in the nature of a
Without
substitute.
objection, the amendment will be considered as read. The gentlelady from Texas is recognized to explain her amendment.
Thank you, Mr. Chairman. It has been really distressing to sit here and listen to my colleagues on the other side of the aisle during this committee markup really go after a private citizen in the way that they have gone after him. And I think this should send chills down the spine of every American to see how, in their desperation, my Republican colleagues are grasping at anyone that they can in any way try to use for their political purposes of attacking the president and his family. What has been especially distressing has been hearing my Republican colleagues talk about Mr. Zwonitzer and the deletion of his materials as though there was some nefarious intent. Like he surreptitiously tried to delete materials as though he was trying to hide information, trying to give the impression that he was basically trying to destroy evidence. And in fact, that term has been used of destroying evidence, when in fact, according to the Her report, Mr. Zwonitzer had perfectly innocent reasons for the deletion. In his interview, Zwonitzer offered plausible, innocent reasons for why he deleted the recordings. This is all in the Her report. First, out of concern for privacy, he had a practice of deleting all audio recordings of interviewees in his possession, and he had done so previously. Second, Zwonitzer was concerned that the materials could be hacked and published online. This concern was increased by his recent work on a book discussing a powerful cyber surveillance system known to target journalists, among other groups. While Zwonitzer admitted to being aware of the special counsel investigation, he did not say that his goal was to keep evidence from being uncovered by that investigation. Instead, he explained, when I got the subpoena and when I realized that I still had audio that I did not know I had on the laptop, I made sure to preserve that for this investigation. And he, in fact, completely cooperated in the investigation. So really, it is incredibly shameful to imply that he was trying to destroy evidence, and in fact, the feds were able to recover that information, and the report made it clear that he complied. So either my colleagues on the other side of the aisle didn't read the Her report, which would be shocking, but unfortunately not surprising. But if they did read the Her report and they knew that the report made it very clear that he complied, then they are just basically trying to sully someone's reputation, which is absolutely shameful. So really, this amendment clarifies that information very succinctly, and there should be absolutely no reason for anyone to vote against this amendment because it is a fact. And I would like to also enter into the record Chapter 17 of the Her report, where this information can easily be found.
Without objection.
Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Question occurs. Gentleman withdraw.
I'll withdraw.
Withdraws his point of order. Question occurs on the amendment offered by the gentlelady from Texas. All those in favor say aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it.
I'd like a recorded vote.
Recorded vote being requested. Clerk, call the roll.
Mr. Jordan?
Nope.
Mr. Jordan votes no. Mr. Isa votes no. Mr. Gates? Mr. Biggs votes no. Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop votes no. Ms. Spartz votes no. Mr. Fitzgerald votes no. Mr. Bentz votes no. Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Mr. Moran? Mr. Moran votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Rulli? Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Ms. Scanlon, you're not recorded. Ms. Scanlon votes aye.
Clerk report.
Mr. Chairman, there are 8 ayes and 11 noes.
The amendment is not agreed to. Gentleman from Georgia is recognized.
Mr. Chairman, I have an amendment at the desk.
The gentleman from California reserves a point of order. The clerk will report.
Amendment to the amendment in
Without
the
objection, the
nature
amendment will
of...
be considered as read. The gentleman from Georgia is recognized to explain his amendment.
Thank you, Mr. Chairman. Well, it's been reported that former President Trump has been livid about the fact that when he left office, he was not offered a book deal. And perhaps that is the reason why, or that's one of the reasons why we're here today. Republicans concerned about Joe Biden's book deal ignores that it is a common practice for public officials and political leaders to publish memoirs that detail their experiences and define their legacies. Numerous Trump administration officials have done so, including Jared Kushner, which makes it even more unpalatable for our dear former president. On June 16, 2021, Broadside Books, an imprint of HarperCollins, announced that it had acquired a book by Jared Kushner. And at the same time of that acquisition, Broadside described Kushner as, quote, playing a central role in the administration's most significant accomplishments, end quote, and said that his book would be definitive, thorough, and thoroughly recounting of the administration and the truth about what happened behind closed doors. Like President Biden, Kushner's memoir was written with the help of a ghostwriter who is identified in the book's acknowledgments as speechwriter Brittany Baldwin. Breaking History, which was published on August 23, 2022, paints Kushner as, quote, one of the most consequential presidential advisors in modern history, end quote, and, quote, takes readers inside debates in the Oval Office, double crosses at the United Nations, tense meetings in Arab palaces, high-stakes negotiations, and the daily barrage of leaks, false allegations, and investigations, and West Wing infighting, end quote. Members of Congress have long raised concerns about the troubling overlap between Jared Kushner's Middle Eastern business interests and U.S. foreign policy. Less than 6 months after Kushner left his role as White House advisor, his private equity firm, known as Affinity Partners, which he has no background in private equity, but still set up this business. And that business received a $2 billion investment from Saudi Arabia's Public Investment Fund, which is a sovereign wealth fund controlled by Crown Prince Mohammed bin Salman. The circumstances surrounding the PIF's $2 billion investment in Affinity invite questions about whether the investment was a reward for official actions Kushner took to benefit the Saudi government during his time in the White House, including preventing accountability for the Saudi government ordering the brutal murder of journalist and American citizen Jamal Khashoggi. Members of this committee have made no secret of their desire to investigate Kushner's business dealings with Middle Eastern states, including Saudi Arabia, and materials created during the process of writing his memoir, including the ghostwriter's notes and audio recordings, could contain evidence that is relevant to such an investigation. And to that end, this committee intends to issue a subpoena to Kushner's ghostwriter for all materials related to Jared Kushner's memoir. There are significant financial transparency issues related to Kushner's memoir. Unlike President Biden, who publicly disclosed how much he has made through book deals, financial terms for Kushner's memoir have not been shared with the public. Moreover, campaign finance records and public reporting indicate that Save America Joint Fundraising Committee, which raises money for 2 political action committees associated with Trump, spent $158,000 buying copies of Kushner's book from Books A Million. These purchases provided direct financial and reputational benefits to Kushner and may have helped him land the #1 spot on the New York bestsellers list. Mr. Chairman, if the contempt report is going to reference President Biden's book deal, it should have this information, this additional information added in for context, and for that reason, I offer this amendment. And with that, I yield back.
Gentleman yields back. Point of orders is withdrawn. Question occurs on the amendment from the gentleman from Georgia. All those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it. Recorded vote being requested. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparks? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Mr. Moran votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Ruley? Mr. Ruley votes no. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
Clerk, Mr. Liu?
Mr. Liu, you're not recorded. Mr. Liu votes aye.
Clerk will report.
Mr. Chairman, there are 8 ayes and 11 noes.
The amendment is not adopted. Who seeks recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report. The gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a substitute to the
Without
committee.
objection, the amendment will be considered as read. The gentleman from Georgia is recognized to explain the amendment.
Thank you, Mr. Chairman. Donald Trump has made a number of bizarre comments that raise serious concerns about his competency and mental acuity. During a June 9th campaign rally in Las Vegas, Nevada, Trump rambled about whether it was better to be electrocuted or attacked by a shark. And this is not the only time he's discussed sharks, Mr. Chairman. Play the shark mashup, please.
I have an aptitude for things. You know, there is such a thing as an aptitude. I said, well, what would happen if this boat is so heavy and started to sink and you're on the top of the boat and you have this tremendously powerful battery and the battery's now underwater? Do you get electrocuted or not? In other words, the boat is going down and you're on the top. And let's say there's a shark about 10 yards over there. Would I have to immediately abandon, or could I ride the electric down? And I said, sir, nobody's ever asked us that question. By the way, a lot of shark attacks lately. Did you notice that? A lot of shark. I watched some guys justifying it today. Well, they weren't really that angry. They bit off the young lady's leg because of the fact that they were not hungry, but they misunderstood who she was. They were saying, oh, sharks, we have to protect them. I said, wait a minute, wait. They actually want to remove all the seals in order to save the shark. I say, wait a minute, don't you have it the other way around? That's true. And the fake news, they go, he told this crazy story with electric. It's actually not crazy. It's sort of a smart story, right? Sort of like, you know, it's like the snake. It's a smart, when you figure what you're leaving in, right? You're bringing it in. You know the snake?
Yeah, y'all can go ahead and laugh about that. It's okay. This past weekend, Trump gave a speech at the Faith and Freedom Coalition's Road to Majority
Time belongs
Conference.
to the gentleman from Georgia.
Mr. Chairman?
Yeah, time belongs to the gentleman from Georgia.
Thank you. This past weekend, Trump gave a speech at the Faith and Freedom Coalition's Road to Majority Conference, during which he claimed that trucks can drive from New York to Los Angeles without stopping. And he talked about the wounds that he received while defending religious liberty, telling the crowd, quote, and I have the wounds all over my body. If I took my shirt off, you'd see a beautiful, beautiful person, but you'd see wounds all over me, end quote. He also advocated for creating a, quote, migrant fight league, end quote, which he apparently pitched to UFC President Dana White. I wonder if he laughed. Later that same day, during a campaign rally, Trump complained about restrictors that don't want you to have any water, and he detailed his typical haircut routine. Let's run that clip.
No water in your faucets. You ever try buying a new home and you turn on, they have restrictors in there. You want to wash your hair, or you want to wash your hands. You turn on the water and it goes drip, drip. The soap, you can't get it off your hand. So you keep it running for about 10 times longer. You're trying. The worst is your hair. I have this beautiful, luxuriant hair. And I put stuff on. I put it in. Lather. I like lots of lather because I like it to come out extremely dry because it seems to be slightly thicker that way. And I lather up, and then you turn on this crazy shower, and the thing drip, drip. And you say, I'm going to be here for 45 minutes. They put restrictors, and they put them on in places like here where there's so much water you don't know what to do with it. You know, it's called rain. It rains a lot in certain places. But no, their idea, you know, did you see the other day? They just I opened it up and they closed it again. I opened it, they close it. Washing machines to wash your dishes. There's a problem. They don't want you to have any water. They want no water.
Gentleman from Georgia, yield just a second.
Well, no, I want to complete my comments. It's not done to cast aspersions on the man Trump, but it is to let the American people know during this hearing, when my friends on the other side are trying to cast aspersions about President Biden's mental acuity, that there is some real evidence that we've got slippage on the part of the Republican nominee for presidency of the United States. And with that, I'll yield back.
Gentleman yields back. Gentleman from California is recognized.
My friend from
Georgia. Withdraw with the point of order.
Withdraw my point of order.
Gentleman's recognized.
My friend from Georgia reminds me of that movie line delivered by Kirstie Alley. Humor, it's a difficult concept. I'll yield the balance of my time to Mr. Bishop.
I think the gentleman, I won't consume the balance, but I would say to my friend from Georgia that the live experience is so much better. You're welcome to come with me to the next Trump rally. I'm sure that would be welcome. But I would also note that it really is amazing that despite the most unprecedented, dangerous, rule of law, killing, turning of the awesome power of the state to prosecute crime against that former president of the United States in order to attempt personally to destroy him. You are so far away from being able to destroy him or the American people that he can still get on the podium at rallies time after time after time and be witty and entertaining and funny and insightful. You aren't about to destroy him or the American people any more than you're about to tip over the island of Guam. I yield back.
Just real quickly, man, you all got to have a little fun once in a while. You don't get it. He's being humorous. It's a joke. He's having a good time. It's one of the reasons, and it was so eloquently said from my friend from North Carolina, through all the hell he's going through, he's still having fun, and that is why his appeal is so broad and so strong with the American people. Humor is a good thing once in a while. Just, maybe just calm down a little bit and learn to laugh a little bit. I yield back.
Well, would the gentleman yield?
Yeah, I can't.
I'm a great proponent of humor, as the gentleman knows.
Time belongs
And I know it can go both ways on you as well, but the fact is we've got repeated instances of the
I'm going to reclaim my time and simply advise my friend of the first law of holes. When you're in one, stop digging. Yield back.
Gentleman yields back. Gentlelady from Texas is recognized.
I just want to bring this back to why we're here. The committee is going after a private citizen, maligning that private citizen, trying to smear a private citizen's name, and it is absolutely unacceptable to those of us on this side of the aisle, and the tactics really are reprehensible, and yet we gave opportunity after opportunity via our amendments to clean up this markup, and each one of our amendments, including an amendment by Ms. Dean, to have our Republican colleagues prove that this is not a purely political stunt, via that amendment, and that they voted that down. I had an amendment to clarify facts from the Her report that would help clear this gentleman's name. That was voted down by the majority. And so I just think it's very important for the American people to understand what's happening here today and how dangerous and reckless this behavior is. Now, with that, Mr. Johnson, do you need any more time?
No, I think this hearing has degenerated to the point where it really is not worth the time of the American people for us to continue to draw this out. The very inception of this hearing is based on trying to develop campaign material for Donald Trump. And then as soon as the truth is shown about Donald Trump, my friends stop laughing. They stopped laughing on the other side of the aisle and start throwing darts and start trying to make excuses for conduct that is frankly inexcusable. It's there for the American people to sit through. If you want to listen to it for an hour, listen to it, take it all in context. It'll take you an hour and a half for some of these presentations that are done, within which these snippets are taken from. But these snippets are real. They demonstrate something to the American people, and you can try to explain it. You can try to throw darts at me for bringing it out, but the American people know me. They also know Donald Trump. They know extremism. They know inefficiency, ineffectiveness. They know vindictiveness. They know all of those extreme qualities that we really don't want to bring back to the White House, but yet here on this committee, we're doing the bidding of this gentleman. We are actually doing what he wants us to do because he didn't get a book contract, because he didn't get this, because he didn't get that. And he orders my friends to carry out vendettas, and Donald Trump has been after President Biden to show that he's a crook. He wanted to put Hillary Clinton in jail. He wants to put President Biden in jail. And if we elect extremists and those who support him, that's exactly what could happen in our democracy. So this is dead serious, but yet this hearing needs to come to a conclusion where we're trying to bully an author, a ghostwriter, to turn over audio notes that Robert Hur has listened to. You know that there's nothing there. The only reason why you want them is to make campaign ads. And we have a lot of material that we can make campaign ads out of from Donald Trump, but I don't know if it'll be necessary or not. So I thank the gentlelady for yielding, and with that, I'll yield back to her.
Mr. Chairman, I yield back.
Gentleman yields back. The question occurs on the amendment offered by the gentleman from Georgia. All those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it.
Recorded vote.
Recorded vote requested. The clerk will call the roll.
Mr. Jordan?
Nope.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Spartz? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Mr. Moran votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Ruley? Mr. Ruley votes no. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush, Mr. Ivy. Mr. Ivy votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Fry, you're not recorded. Mr. Fry votes no.
Clerk will report.
Mr. Chairman, there are 8 ayes and 13 noes.
Amendment is not agreed to. Questions on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the report. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the amendment in the nature of substitute is adopted. A reporting quorum being present. The question is on favorably reporting the report as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the recorded vote being requested. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. Biggs votes yes. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes aye. Ms. Sparks? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Mr. Moran votes yes. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes yes. Mr. Rulli? Mr. Rulli votes yes. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. Dean? Ms. Dean votes no. Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no.
Clerk will report.
Mr. Chairman, there are 13 ayes and 11 noes.
The ayes have it, and the report is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 2833, the Pretrial Release Reporting Act, for purposes of markup, and move the committee reported favorably to the House. The clerk will report the bill.
H.R. 2833.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Mr. Chair. On November 5th, 2021, Darrell Brooks Jr. was arrested and charged with felony reckless endangerment after running his girlfriend over with his car in a gas station parking lot. On November 16, 2021, Mr. Brooks was released from the custody of the Milwaukee County Sheriff's Office on a $1,000 bond. 5 days later, on November 21st, 2021, Darrell Brooks drove his SUV through the annual Waukesha Christmas Parade, injuring over 50 individuals and killing 6, including an 8-year-old child. I wish that cases like these were rare, but unfortunately, Mr. Chairman, we're seeing them all too frequently. That's because liberal cities and rogue state prosecutors are seeking to limit or altogether abolish the use of cash bail. For example, after New York passed its bail reform law, recidivism rates increased for individuals who had previously violent felony offenses. A March 2023 study by researchers at John Jay College of Criminal Justice found that approximately 72% of violent felony offenders who were released without bail were rearrested. Similarly, in January 2023, the state of Illinois began implementing its, quote, safety law, which stripped judges of their ability to set cash bail and require prosecutors to provide evidence within 48 hours that provide the offender committed a crime that posed a, quote, significant threat to public safety, unquote. While it's still too early to know the full impact of this law, counties across the state, such as McHenry County, are already reporting an increase in those charged with subsequent felony offenses. Meanwhile, the city of Chicago was awarded more than $2.6 million in burn JAG grants in 2023 to support Illinois reckless bail policies. The Bureau of Justice Statistics, which is tasked with collecting, analyzing, and publishing information on crime, criminal offenders, and the operation of our justice system at all levels of government, have previously reported pretrial release of felony defendants in state courts through its National Pretrial Reporting Program, or NPRP. The most recent NPRP report is from 2007, so it's rather dated, but it is it did evaluate pretrial release statistics between 1990 and 1994. I think we can all agree it's time we received updated reported data. That's why I introduced H.R. 2533, the Pretrial Release Reporting Act, which would task the Bureau of Justice Statistics to report on individuals charged with violent felony offenses who are subsequently released on bail or obtain pretrial release. I hope my colleagues on the other side of the aisle would agree that this data would be helpful informing Congress of how state and local prosecutorial decisions are impacting the safety of their communities and would hopefully prevent future tragedies like the one that occurred in Waukesha. I urge a yes vote on this bill, and I yield balance of my time.
Gentleman yields back. Gentleman from Georgia for an opening statement is recognized.
Thank you, Mr. Chairman. Masquerading as a purportedly harmless reporting bill, H.R. 2833 is actually just another baseless attempt by my Republican colleagues to engage in fear-mongering about crime despite historic drops in violent crime in cities across the country. Their target this time is bail reform. The premise underlying this bill, that bail reform in cities with so-called progressive prosecutors has created a dramatic ongoing increase in violent crime, is simply not true. It's wrong. As if that weren't bad enough in trying to justify their false premise, the bill requires but does not fund a report that would be simply impossible to complete, certainly not within the 180 days given, much less every year thereafter. Let's start with the supposed justification for this bill. It rests on the outdated and completely disproven notion that violent crime is on the rise and that bail reform is somehow to blame. But this simply is not true. With the onset of the pandemic, increases in crime were felt in communities of all sizes, political alignments, and demographics, and in states that enacted bail reform policies, and just as much or more in states that did not. And murder rates have been higher in red states than in blue states in every year in this century. More importantly, the statistics conclusively show that violent crime has been falling dramatically for more than 2 years under the Biden administration, even in states that changed the way they look at bail and pretrial release. Although the majority would like to pretend otherwise, crime rates began to drop in 2022, while 2023 featured one of the lowest crime rates in more than 50 years. And crime rates continue to fall even further in 2024. Despite what our Republican colleagues want Americans to believe, the evidence fails to show any causal connection between bail reform and crime. However, cash bail has resulted in a dramatic rise in the number of defendants who are detained pending trial, resulting in tremendous financial and social costs to defendants, their families, their communities, and taxpayers who bear the cost of incarcerating nearly 450,000 people each year who have yet to be convicted of a crime. It's not surprising that the burdens of pretrial detention fall disproportionately on communities of color and on women as well. As a result of the growing body of research demonstrating the ineffectiveness and inequities of the cash bail or fixed bail system, a number of states and local jurisdictions have made efforts to reform their bail practices in recent years, and the data show that bail reform has not led to an increase in crime or recidivism rates. In the state of New York, which instituted bail reform at the beginning of 2020, fixed bail is still used for violent felonies, but for misdemeanors and nonviolent felonies, defendants are released on their own recognizance or under individualized, tailored conditions designed to ensure their appearance in court. 3 separate studies have shown that while crime rates in New York did increase in 2020, as they did throughout the country, bail reform was not a driver of that increase. One study found that eliminating bail for misdemeanors and nonviolent felonies in New York actually reduced rearrest rates. And of course, in New York, as in the rest of the country, crime has been declining precipitously. The other fundamental problem with this bill is that it imposes an onerous reporting requirement that the Bureau of Justice Statistics, or BJS, will not be able to meet. The bill would require BJS to obtain data from all state courts in the country without defining that term and without recognizing that much of the data that the bill would require BJS to collect is not housed in one central location. To truly fulfill this mandate, BJS would have to go to courts as well as jails and multiple pretrial service agencies in every single jurisdiction in the country to collect the data. This would be nearly impossible without a massive infusion of resources that this bill does not provide. And such a report is not necessary because it is entirely duplicative. As recognized in the findings of this bill, BJS awarded a grant of $2 million to the Research Triangle Institute in 2020 to conduct a study of pretrial release through the National Pretrial Reporting Program, which BJS first initiated in 1988. Although the study was slowed down for years by the pandemic, it is still underway, and BJS anticipates that it will be completed by the end of this year. Rather than imposing an impossible annual burden on BJS without appropriating a single dollar to fund that burden, we should wait for the completion of this ongoing work. Of course, if my colleagues across the aisle really wanted to address violent crime, they could invest in community violence intervention, fully fund the ATF, enact common sense gun legislation, and provide targeted support to law enforcement. Democrats have consistently supported such efforts while Republicans have repeatedly blocked and tried to defund them. Although I am typically inclined to support reporting bills, as are many of my colleagues, I simply cannot support this legislation. Rather than gathering new data and useful data, it creates an unfunded mandate with which BJS cannot possibly comply to launch a misguided attack on bail reform. It's disappointing that Republicans would rather demagogue on the issue of crime than work with Democrats on solutions that would truly make our communities safer. With that, I yield back.
Gentleman yields back without objection. All of the opening statements will be included in the record. The chair now recognizes the gentleman from Wisconsin for the purpose of offering an amendment in the nature of a substitute.
Yeah, Mr. Chairman, I do have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection,
HR.
the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair recognizes the gentleman from Wisconsin to explain the amendment.
Well, Mr. Chairman, as I mentioned in my earlier remarks, the last report that was produced by the National Pretrial Reporting Program, it does rely on data that's over 20 years old. So we should not be relying on the outdated statistics to guide the committee's oversight of the federal funds, like the burn JAG, which I talked about earlier. So this amendment is in the nature of a substitute, would make to report annual, giving Congress up-to-date statistics on how state and local prosecutorial decisions are impacting the safety of our communities. This is really the only substantial change, but I do believe that it would respond to some of the concerns that I heard from the other side of the aisle. So I urge the adoption of the amendment in the nature of substitute, and I yield back.
Gentleman yields back. Gentlelady from California, and I'll come to the gentleman from Maryland.
I move to strike the last word.
Gentlelady's recommended.
I just want to first thank Mr. Johnson for his very cogent remarks. I think he laid out quite accurately the statistics, potentially the motive for the bill. Really, there's no there. But I thought it was important to note that the Bureau of Justice Statistics is actually going to complete their report on this very subject by the end of this year. And so this bill is completely unnecessary. I would note also that there was some analysis done by the department, an advisory, that went through some issues that I think that this bill does not accommodate. For example, to collect the information relevant to pretrial release decisions, you need more data than is generally available. For example, how do you distinguish between pretrial release programs and those that are released because of limited budget or by court order for jail overcrowding versus pretrial risk assessment? That information just can't be collected. And unfortunately, this bill has the same problem. Honestly, since this bill is never going to become law, I don't think it matters whether we vote yes or no. I certainly want to get the information that we will get by the end of this year from the Bureau of Justice Statistics. Certainly, every Democrat on this committee is looking forward to getting that accurate data by the end of this year. And so it's disappointing that this bill is being considered today. Perhaps the committee was not aware of the deadline that has been promised and the new information that we will have by the end of this calendar year. So maybe I'll vote for this bill. It really doesn't matter whether you vote yes or no, because this bill is never going to become law, and actually the information is going to become known to this committee and the world by the end of the year by the Department of Justice. So I just wanted to note that, and also to once again thank Mr. Johnson for outlining the facts, which is the various scare rhetoric about crime is really misplaced. Crime is falling across the United States, and there is some of the overheated rhetoric around the country is really misplaced, and an effort, I think, to alarm people. Obviously, there is some level of crime in every community, in every country, and we are not immune from that. But to spin that unfortunate fact into an emergency that is beyond background is inappropriate, and I think not a service to the public that should be not scared beyond the facts and the truth. So with that, I just wanted to lay that out, that we will have this information by the end of this year. It will be accurate information, and this bill is completely unnecessary. And I don't know if Mr. Johnson has additional comments, or Mr. Ivey, the gentleman from Maryland, I'd be happy to yield. I'd yield to Mr. Johnson.
Thank you. I would, Madam Chair, thank you for, Madam Lofgren, thank you for yielding. I would like for the record to ask for unanimous consent to enter the following documents. One is a 2013 report of the National Pretrial Reporting Program, which demonstrates that contrary to what is stated in this bill, the last NPR report was not in 2007. And also documents submitted by the Bureau of Justice Statistics to the Office of Management and Budget in support of BJS's information collection requests for the currently ongoing National Pretrial Reporting Program study.
Without objection.
With that, Mr. Chairman, I yield back.
Gentlelady yields back. Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. You know, I share the concerns that have been raised already. I just wanted to point out a few more as we go forward. The point that was made earlier about a study that is due, this may be what's referenced ironically on page 2 of the bill, which references 2020, the National Pretrial Reporting Program of the Bureau of Justice Statistics awarded a grant of $2 million. So that may be what the report that's forthcoming. It's a little ironic that, you know, we're going to have a legislation that's going to require the use of that money to do what's already in the pipeline to get done. And there ought to be some kind of coordination with respect to that. Because these are heavy unfunded mandates. You know, I was the local prosecutor in Prince George's County, which is just under 1 million people. And so we have a sizable apparatus there. And, you know, the Maryland state courts have a pretty large apparatus, too, as far as data collection. But I don't think even we get that granular. And I would think that there'd be many states, local prosecutors' offices, local police officers, police departments, and states that just don't have the apparatus in place to collect all of this information without getting significant funding to do it. You know, and so I think we should, if we're going to request this information at this scale, especially with what I think is an impossible turnaround of 180 days, this is a very massive request for data. Turning that around in 6 months, I think, is unrealistic. And if we are going to really seek to do that, I think we should probably try and figure out what kind of funding would be needed. My thought would also be to reach out to state and local law enforcement and ask them what they might need to try and produce this kind of information. Are they able to do it under, you know, which states, which counties, which jurisdictions are able to produce it, you know, in their current circumstances? Which ones are going to need help? Because if they're going to need help, I think it's incumbent on us to help provide it if it's information that we want to get. And then, you know, with respect to the drafting of this, and this isn't uncommon in these kinds of criminal provisions, but I don't see this reference to other provisions that have tried to address this issue. So, and that goes to the issue that states define particular offenses in different ways. And so, you know, rape or attempted rape, in some states, they don't use those terms. They have sexual assault. I see sexual abuse there, but some states don't define it in that way. In fact, the abuse term is frequently used for child abuse, which isn't mentioned in here, I don't think, as one of the things we would want to track. But from my perspective, child abuse, especially violent child abuse, would certainly be one of the things we'd want to know about and track for these kinds of things, because if you have a serial child abuser, and we're trying to figure out whether these people are getting pretrial release or, breaks on detention or not that's inappropriate, isn't that the kind of information we'd want? I would think so. Resisting or obstructing an officer is another one. Sure, let's track that, but different states define it different ways, and some of them would say, like, rather than a resisting or obstructing an officer, assaulting an officer, especially if it's a violent assault, which might not be captured, depending on the state you're in, by resisting or obstructing. I think under the federal law, as a matter of fact, resisting or obstructing is different statutorily than assaulting a police officer. But again, I think we would want to know if people are assaulting police officers and they're getting out, faster than they should, or they're not getting bail, whatever that is, definitely the type of information I would think that we'd want to know and collect under these sorts of circumstances. Recklessly endangering safety. I mean, I don't know for sure what that means, but that's another one of those types of provisions. I mean, Maryland's got reckless endangerment. Is that what's included here? Could be a scenario where it's violent, could be a scenario where it's not. But, the Bail Reform Act, for example, which touches on, I think, the issues you're trying to get at here, at least at the federal level, has gone through the process of making these definitions applicable and giving guidance on how to apply them. It would seem to me that we'd want to tap into that so that we don't run into the same problems that they had and try and reinvent the wheel. So, and the term violent, by the way, is also another one that needs to be defined. For example, some provisions say drug dealing is a violent offense. So I would say if we want to do this, and collecting data I think is useful and important, I wouldn't necessarily oppose it, but let's not reinvent the wheel. Let's try and do it in a way that is going to work and doesn't impose unfair mandates and unfunded mandates on state and local law enforcement. With that, I yield back.
Gentleman yields back. Gentleman from Wisconsin is recognized.
I'm sensitive to some of the comments that were just made. I guess what I would first say is I'd love to work, and we have been working with members of the Senate to develop a strategy that's going to result in something more than what BJS has been working on since 2020. They spent about $3 million already and have really, we have no idea what's going to be turned out at the end of the year. So that would be my first response. The second is, I didn't dream up this bill. This came from prosecutors. It came from those involved in law enforcement who right now are saying there's such a patchwork, not just in the 72 counties within my state of Wisconsin, on the difference between what's being prosecuted and the types of crimes that are being prosecuted, or those that are being, at the end of the day, kind of dismissed as not serious crimes. I mean, they're asking for consistency, and they need a national strategy, and I'm not a big proponent of that all the time, but I think they're asking for a national strategy on coming up with this data versus kind of a patchwork. And, I think that's why the bill certainly, could be, there could be changes made. I'm not necessarily hung up on some of the definitions that Congressman Viney just brought up. I think, the same thing. I think there is some wiggle room on some of that stuff as well. But the point is, we need to get something going now, because what we're seeing is that this is absolutely hampering prosecutors' abilities and public defenders throughout the nation to try and understand what is going out there on the street and how should they be dealing with those situations. So I think there's no better time to bring this bill forward, not just because of some of the recent high-profile incidents that have happened nationwide on this front that you could characterize as, well, there's an inconsistency, that's simply as fine as the county line, it doesn't make much sense right now. That's where I think the report makes sense, and quite honestly, I'm not looking for anything of great substance that's going to come out at the end of the year, unfortunately, with a lot of money that's been spent and with, 3 years down the tubes. So I would yield back.
Gentleman yields back. I'll claim time and yield to the gentleman from Maryland.
I would just say this, and we're working together on legislation, I think in good faith and trying to figure out not this particular provision, but if the gentleman, if you'd want to withdraw it, or we could try and work together and figure out how to fix it and move it forward, I'd be more than happy to try and work with you on that. And also, I share you. I don't know what we're going to get out of the bill, out of the report that's being done, and I think Mr. Johnson pointed out that there was a huge overlap with respect to COVID that would have a huge impact and distortion effect on this report during those years. But I'd be more than happy to work with the gentleman to try and figure it out, because I think this is information that could be useful if we go about getting it in the right way. And with that, thank you, Mr. Chairman. I yield back to you.
Gentleman yields back. I yield back. The question occurs on the amendment in the nature of a substitute. On adoption of the amendment in the nature of substitute, this will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is now on favorably reporting the bill as amended. All those in favor say aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views.
I'd request a recorded vote.
Recorded vote is requested by the gentleman from Georgia. The clerk will call the roll.
Mr. Jordan.
Maryland, excuse me, I'm sorry. Go ahead.
Mr. Jordan.
Yes.
Mr. Jordan votes yes. Mr. Issa. Mr. Gates. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes aye. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Bishop. Mr. Bishop votes aye. Ms. Sparks. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Bentz. Mr. Bentz votes aye. Mr. Klein. Mr. Klein votes aye. Mr. Armstrong. Mr. Gooden. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Moore votes aye. Mr. Kiley. Ms. Hageman. Ms. Hageman votes aye. Mr. Moran. Mr. Moran votes aye. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Fry votes aye. Mr. Ruley. Mr. Nadler. Ms. Lofgren. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson. Mr. Johnson votes no. Mr. Schiff. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Mr. Correa. Ms. Scanlon. Mr. Neguse. Ms. McBath. Ms. Dean. Ms. Dean votes no. Ms. Escobar. Ms. Escobar votes no. Ms. Ross. Ms. Ross votes no. Ms. Bush. Mr. Ivy. Mr. Ivy votes no. Ms. Ballant. Ms. Ballant votes no. Ms. Scanlon, you are not recorded. Ms. Scanlon votes no.
Gentleman from Ohio.
Mr. Rulli? Yes. Mr. Rulli votes yes.
We can take 4 more of anybody, though. Mr. Isa, you are not recorded. Mr. Isa votes yes. Gentleman from Wisconsin.
Mr. Tiffany? Mr. Tiffany votes aye.
Gentlemen.
Mr. Kiley, you're not recorded. Mr. Kiley votes aye.
Hey, Kevin, have you voted on the first one? You haven't went over and voted at all yet? On the
Brock? Brock, take the chair. Take the chair.
Where's Kylie at? Clerk will report.
Mr. Chairman, there are 15 ayes and 7 noes.
The ayes have it, and the bill is ordered to be reported favorable to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as some single amendment in the nature of a substitute, incorporating all adopted amendments, and the staff is authorized to make technical and conforming changes. The committee will stand in recess. This concludes, the committee will come to order. That concludes the committee's business for today. The committee is adjourned.